You can start, ma'am.
Thank you, sir. The Oxford College of Business Management, under the aegis of Children's Education Society, is one of the leading institutions founded by late Sri S. Narissa Raju Garu, and the unprecedented legacy is being continued by our chairman, Sri SNVL Narsimha Raju Garu, sir. The Oxford College of Business Management's phenomenal growth translates the linkage between industry and academia, research focus, and prominent teaching fraternity into its consistent academic quality. The Oxford College of Business Management focuses on three core principles: education, research, and social participation, and we incorporate all three into our commitment with students and stakeholders. I, Avinash Kaur, Assistant Professor on behalf of the Oxford College of Business Management, welcome you all. In today's globally competitive environment, intellectual property has placed itself on a pedestal in the context of economic growth and is becoming increasingly important. Intellectual property is the fuel that powers the engine of prosperity, fostering invention and innovation. On the above backdrop, the Oxford College of Business Management, in association with Internal Quality Assurance Cell, has organized one-day workshop on intellectual property rights. The focus of the workshop is to promote the creation, protection, and enforcement of the intellectual property rights amongst various stakeholders. To start with today's session, I would like to welcome Dr. Nikita Alur, Principal, the Oxford College of Business Management, to deliver the welcome address.
A very good morning to everyone. It's my sincere pleasure to welcome all the dignitaries, faculty members, and dear students to this virtual workshop on intellectual property rights to enrich the knowledge of students through interaction with distinguished personalities from industry and academia. Intellectual property is an intangible creation of the mind, which is protected under patent, copyright, or trademark laws. As an undergraduate or postgraduate student, you have an opportunity to make original creations, inventions, and discoveries as part of your activities both within and outside the classes. Learning about these forms of intellectual property and how to protect and develop them is an important part of your educational experience. The COVID-19 pandemic has re-emphasized the importance of access to intellectual property during a crisis. So this is especially true in three key sectors, that is public health, education, and entertainment industry. Well, we have with us two intellectual personalities, and it gives me immense pleasure to welcome Mr. L. Vijayaraghavan sir, who is a specialist and has vast experience and knowledge in the field of IPR and ADR, that is alternative dispute resolution. Thank you so much, sir, for accepting our invitation to share your knowledge and wisdom. I also take this opportunity to welcome Mr. Sanchit Egre, a senior partner at Banana IP Council, a premier intellectual property firm. Thank you, sir, for accepting our invitation to add light into the workshop on intellectual property rights. It's my sincere pleasure to welcome all our distinguished guests, faculty members, students of the Oxford College of Business Management, and also students from various colleges across India for this workshop. Thank you all. The main objective of conducting this workshop is to create awareness on intellectual property rights and patents, to develop academic and industrial research perspective, and to protect and explore IPRs. So we have the experts with us over the next couple of hours who will guide us to understand the importance of intellectual property rights and also address the younger generation about the business of intellectual property and opportunities for commerce and business students. I'm sure this workshop will be beneficial for all the students and faculty members. Thank you, one and all. Take care and stay safe.
Thank you, ma'am.
Thank you so much, ma'am. It is with deep pride and humility that I introduce the first speaker of this workshop, an individual who has effected change and a person of pioneering spirit and willingness, Mr. L. Vijayaraghavan, intellectual property rights and alternate dispute resolution specialist. With 38 years of working experience, he has been a part of various organizations and institutions. He has worked as visiting faculty in institutes such as Christ University, Mount Carmel College, Bangalore, Symbiosis University Law College, Alliance Business School, Bangalore, to name a few. He has 10 years of organizational experience as Deputy Manager, Marketing, Legal and Human Resources in Kinetic Motors Limited, Pune, and has also worked as Deputy Manager, Accounts and Finance in Honda Company. Mr. L. Vijayaraghavan has filed various cases under Consumer Court, undertaken various civil action, criminal action, corporate and securities law action. I welcome you, sir, and request you to take over the session. I just would like to request the participants to disable their videos and audios and can put across the questions in the chat box, which will be answered at the end of the session. Mr. L. Vijayaraghavan, sir, I hand over the session to you.
Thank you, ma'am. I am Professor L. Vijayaraghavan. I have a background of 28 years of industry experience and 10 years of visiting faculty with management, with several management colleges. I have worked in big corporate groups like Honda Company, Integral Coach Factory, Railways, that is a government organization, and other individual group companies also I have worked. I have worked in the fields of law, IPR, HR, accounts and finance divisions. To bring perspective to the present seminar, so first of all, I would like to know what is a property. People call property in a sense that they own it. This is my property, people say. Yes, he is right. This is his property. So what he can do with his property? He can sell, he can mortgage. Suppose this pen is my property. See, I can use it, I can throw it, I can sell it, I can mortgage it. A bundle of, what is a property? A property consists of a bundle of rights. I can break it, I can buy 1 minute back this pen from a shop owner. Now I am the owner of this, I can break this. Anybody is asking, what I will say, no, it's my property, don't interfere, like that. So a property consists of a bundle of rights, but you can see this. This is called as a tangible. Tangible means what you can see. Table, chair, computer, all these things where you can touch, you can see. All these things is called as tangible properties. And tangible properties are two types. One is called movable property and immovable property. See, what is a movable property that can move? That is car. Car can move. So it's a tangible, it's a movable property. What are immovable properties? Earth, that is land. Land is immovable. You cannot shake it. Building, see, that you cannot shake it. See, even the concept of immovable property under property category definition is very wide. Even a window which is attached to a building is treated as immovable property. Even though the window can be separated, but that is attached with something, the building which is attached to the earth. So that is why it is said that even a window is also treated as a movable property. And another kind of properties are all called as intangible property. Intangible is that we cannot see. Like patents, designs, copyright, and all that. They are rights. They are also called as a property rights, but they cannot be seen. They are born out of our mind, human mind. See, something like patent, which you invent something anew, a patent product. Suppose COVID, there's a medicine for COVID. So some organization has invented this medicine. So this medicine is also treated as a property, but it is called as intellectual property. And copyright is also creations of human mind. For instance, you will find Ramayana, Valmiki has written. It has come out of his mind. Ramayana, Mahabharata, Vedavyas. See, these are all called as a copyright. And cinema, the cinematograph, that cinema which you see is also the creation of human mind. So these are all called as the intellectual property. And not only that, designs are also treated as a movable property. The shape of a vehicle is a design. The textile design is also protected under the intellectual property rights. But the question arises is whether what is a patent? It's a creation of human mind, and patents are granted for what purposes? It is for the purpose of inventing something. It should be a new invention. It should be anew, and which is not obvious. If everybody can do it, then that is not a patent. And that is capable of industrial application. See, whatever you invent, it should be capable of industrial application. Then only it is treated as a patent. Next is, what are the uses of intellectual property rights? See, broadly, we are management students. Most of them, I feel, they are management students. Why we should study about intellectual property rights? See, companies, they produce patents. When they produce patents, not that all patents are used by the company. There is an R&D department in every company. I worked in a Honda company. There is an R&D department, and that company produces several new patents. Well, it may be enhancement of petrol efficiency, or it can be anything. But when they file the patent with the patent office, but it is not that every kind of patent is being exploited by the company into products. So for instance, Google may have a number of patents. Suppose they have something 10,000 patents they have in their shelf, in their R&D shelf. Not all these are being used by the company. So what it can do, management of IPR rights comes in this. Some of the patents which already they have invented, they can sell it to others for a cost. Suppose producing that particular patent costs something like 200 crores. They can sell it for 250 crores or 300 crores. So you are getting money returned out of that. That which you are not using it, but you are selling it and getting it. So this is one method. Or you can also do the other way. Whatever patents that the company has done, which is not being used, it can give a license to any other person to produce the thing for 5 years. It can get a certain sum of money, like 500 crores, like that it can get. After 5 years, it can take back. There is a take back. It need not renew it, and you can give this license to another person. Law does not prohibit licensing of intellectual property rights to one only. A company, Honda, which has designed a particular invented a particular patent, it can give license of its product to a number of persons. See, but it can get money from everybody. So it is effectively using the patent that is produced by them, which is not being used by them. Patents are also a source of competition. See, what I do, Google says, I have invented this patent. Now, no other person can invent this. In the same way. So what it happens, it limits the competition. So it is treated as a safeguard also for a company. It is using it as an offensive. If any other company is making a patent, which already Google has done, it will launch a criminal proceeding. It will launch a court proceeding against the person who is violating its orders, violating its invention. So it is treated as an offensive also. You invent and use it as an offensive. So you limit the competition. So others, it prevents any other person from coming up into the same kind of business. So the first company becomes the monopoly. So in that way, patent is used both for positive as well as for negative also. There are certain kinds of inventions for which patent is not granted. For instance, natural laws, law of gravity. See, I think Einstein has invented law of gravity, but for law of gravity, there is no patent. Why there is no patent for law of gravity? It is natural laws, scientific laws. It is universal in nature. It is for the entire humanity. Nobody can claim a monopoly over its invention. So scientific laws. Then a kind of medical treatment. See, suppose there is a heart operation. A particular doctor has invented a method of heart operation. That is a method of operation. So the doctor will not be given a patent. Maybe it may be innovative. For instance, previously they used to open this chest and then do the heart operation. Then advancement in heart surgery came with the result that angio without opening your this particular portion, they can operate it because it's some angiotherapy like that they call it. So these are all medical advancement for which there has been considerable time and investment in terms of money and time has been made by the company or the particular person who is the inventor, but the patent is not granted for it. Why? Because in public interest, what will happen? All throughout the world will have to give royalty to that person who has invented that. So it is against public interest. Yeah, method of agriculture. There are methods of agriculture. One kind of method of agriculture is drip irrigation, where a long tube is there, small holes are made, water is, tap is open from one side, and the water is coming. It is so, the hole is so small that seepage of water is very in limited quantities. There is no vast wastage of water. And the plant also is not suffering from excess water with that. So it's a method of agriculture, but no patent protection for any method of agriculture. And let us come to the field of mathematics. 1 + 1 is equal to 2. A plus B is equal to C. They are axioms, self-accepted axioms. Another person can differ. 1 + 1 is equal to 2, no 3. Management will always say, as a management person, I will always say 1 + 1 is not equal to 2. It is 3. How? Because 2 persons produce the work of 3. 3 persons will produce the work of 5. See, cooperation leads to more than 1. So that is why it is that 1 + 1 is equal to 3 in management. In arithmetics, mathematics, 1 + 1 is equal to 2. This 1 + 1 is equal to 2 has been invented by somebody, or 0 has been invented by Indians, but no patent is given in respect of these kinds of inventions. Why? Because they are in public interest. It is not given. They are mere. And yeah, method of presentation is also there. See, how I present a particular lecture or how information is presented, that is also not capable of being given patent protection. Another, we have seen geographical indications. For instance, Champagne wine. See, Champagne wine originates from France. That's from Champagne district. In that district, Champagne wine is made, and that is the number wine across the globe. It is a much softer wine. But this particular Champagne wine is coming from a particular area, and a process is there to make that wine. So it gets a geographical indication tag, in the sense that no other person can invent the same kind of wine and say it is Champagne wine. So it's a geographical indication. Geographical indication means the product comes to a particular area. For instance, you take basmati rice under geographical indications. Basmati. See, throughout the globe, it is recognized that India and Pakistan are the two countries which can produce basmati rice. No other person can do. But what happened if somebody claims other country like USA, UK, they sell a particular rice, a basmati rice. See, basmati rice only from India and Pakistan. The quality, how it is sold, everything. So it gets geographical indication tag. Tirupati Laddu, see, Tirupati Laddu, it has got a geographical indication tag. Why? Because the kind of laddu that is made in Tirupati, it remains without getting affected for a month also. Whereas if you buy outside from a sweet shop, see, 1 or 2 days, it may swell bad. So geographical indication means it's a kind of a process which is coming a particular area, Tirupati, Andhra Pradesh. So it has also got the geographical indication tag. Assam tea. It tastes in a way which is different from others. Even you take up the land mass. See, the land mass, the fertility which is available in Assam may not be same in Chikmagalur in Karnataka. It may be different. The soil conditions may be different. See, Chikmagalur coffee estates, Chikmagalur tea estates, they produce a kind of a tea which is different from Assam tea. So, the IPR also consists of the geographical indications, and you have Alfonso mango, which is produced from Maharashtra. Alfonso mango. The Alfonso mango has got a taste which is different across the globe. So it has got the geographical indication stage under IPR. IPR is a legal right. It's a legal right. It is recognized under the law of the land. In India, we have Patent Act. We have Patent Act 1970. Based on that, any invention that is done by any individual or an organization, they can get a patent from Indian Patent Office. Controller General of Patent Office, he can get it. The moment he engages in a research, you should see the literature in the area across the globe, anywhere anybody is doing it. Then once he is satisfied that across the globe nobody is doing it, then you can start that invention, and you can file that invention with the Controller General Office. Then Controller General Office, they will publish that particular invention in a patent journal. Patent journal, Indian Patent Journal, is globally accessible, globally acknowledged journal. So once your invention appears in that, anybody across the globe can file objection saying that we have already invented in our country, or I am the first inventor of this. So this is not a new invention, because patent is given only for new invention. So naturally, other person can oppose it. That is called as opposition proceedings. The Controller General Office will conduct the opposition proceedings. They will call all objectors to file their objections, and then the Controller General Office will give an order whether the patent filed by an Indian in India holds good, or it does not hold good. So he can give his decision. Apart from this, trade secrets are there. There are some trade secrets which are also part of intellectual property rights. For instance, you will find, see, Coca-Cola mixture, the mixture of the chemical formulations. Nowhere it is declared in patent as a patent. Actually, that chemical formulation is a patent, but they have not declared that patent, because once you declare, so you have to indicate how the chemical formulation came into being. You have to demonstrate, you have to prove, you have to make it as part of the patent application, complete patent application. So this has not been done by Coca-Cola. What they have done, they have kept it as a secret. It's a trade secret belonging to the trade. And throughout the globe, it is said that only 5 persons throughout the globe know that chemical formula. No other person knows it. So this is why chemical formula is kept as a trade secret because once it is declared in the patent application, others will also do it after a period of time, and the patent period expires. Another person can use it, can use the same, produce same Coca-Cola. What will happen to original research made by Coca-Cola? So that is why it is said that some secrets are treated as trade secrets, and that is also a kind of an IPR. Next is trademarks. What is a trademark? A trademark, we have seen, it indicates the product from where a particular that is, suppose you say Tata salt. See, there is a trademark, Tata is written, and it may be a signature or a design or anything. So that indicates that where from the good is coming. See, when you buy a particular product, you go by trademark. Give me Tata salt, you say. Or, for instance, some products are known only by trademark, like Bonvita. See, people ask Bonvita. Say, I want Bonvita. Bonvita is given. But who is manufacturing that? Customer doesn't know. Customer, he says that trade name is Bonvita. So what it means, that indicates a market. It indicates a market for which a specific group of people buy that trade name. So it is actually produced by Smithkline Company Limited. Bonvita is produced. Industrial design is also a part of intellectual property rights. Industrial design, how it is made, and you will also find that trademark, you have to register the trademark. There is no expiry period for a trademark. For instance, you should renew it every 10 years. And another condition for a trademark is that it should be continually used, not continuously. Continuously is different. Continuously means 2010, 2011, 2012, 2013, 2014. Like continuous. Continual means 2010, 2012, 2015. That is all continual. Let's say continuity is there. In between, the product was not made. So trademark requires continual use. So after end of 10 years, it can be renewed. But the thing is, there is no expiry for a trademark. See, for instance, a patent is there. Suppose the inventor has invented a particular machine, welding machine, which can work very efficiently. I work in companies, industries. I know about the shop organization. So there are various methods of welding, CO2 welding, arc welding, butt seam welding. There are various methods of welding techniques. Welding is joining two parts. This part is there, this part is there, this part is there, joining with the electron. So there are many methods. CO2 welding is supposed to be the efficient method. So this particular, suppose there is a machine is doing this work. That machine has been invented by an inventor. Then there is an expiry period, 20 years only will be given. Beyond 20 years, it will go into public domain. It will go into public domain. Public domain means anybody can make that machine without giving any royalty to the inventor. But experience has shown, I have seen the patent office data. I made a research into it, but no company. And if you want the continuity of 20 years, you have to pay renewal fee. So every 3 years, renewal fee you have to pay. Individual companies who invent a particular machine or a product, and for which they got the patent, what they do not do is after 5 years, they don't pay the renewal fee. So if anybody is using that, the original owner cannot file a case against the perpetrator or the perpetrator of the crime. The thing is, why they are not doing it? After 5 years, it is not renewed at all. Though patent They can renew it for another 15 years, balance 15 years. The thing is, there is constant advancement of technology. See, new inventions are there. So due to these new inventions, what happens? The old technology goes into disuse. New technology takes over. When new technology takes over, naturally, if you start paying amount for the expired one, it is only useless. So that is why after 5 or 6 years, for the inventors do not pay the renewal fee, and others they make that product without payment of any royalty to the original inventor, and original inventor does not proceed in a court of law for the violation of the his patent rights. Now let us come to some kind of a copyright. See, what is a copyright? See, copyright exists in ideas. Copyright does not exist in idea, but in the expression. See, for instance, Valmiki Kavi, Adi Kavi has written Ramayana, Veravyas, Mahabharat, and all that. 18 Purans he has written. But Kavi Kalidas would take. He has written a lot of works, Kavi Kalidas works, Meghaduta, and so many. He has written Raghuvamsa, Meghaduta, all these things. But none of them hold idea on copyright. Suppose Kavi Kalidas has described about Himalayas. It's a moot point to ask whether Kavi Kalidas has gone to Himalayas to describe about Himalayas. There are a lot of controversy is there, whether he could have gone or not. That is not a point of discussion. The point of discussion now here is that Kavi Kalidas has described about Himalayas. So suppose if copyright is given to him for describing Himalayas, what will happen? Others cannot describe Himalayas. So that is not the object of copyright. It says copyright does not exist on ideas, but only in expression. The way he has written, another person cannot make a Xerox copy of it and say. So that is one important portion in copyright. And producer of film, see, producer of film, cinematograph. There are in a film, there are many persons are involved in a film. The producer, the actor, the actress, the joker, and some fighting people involved. The poet who has done the poem as part of the film, and the singer who has sang that song in the film. So you have a number of people associated with the cinema, but the copyright exists only with the producer. No other person can claim copyright separately apart from the producer of the film. So copyright exists in him only. Another way is you can also say that everybody write about Ramayana. See, Valmiki has written Ramayana. Okay, you can also write Ramayana. You can also write Ramayana. So you can also write about Ramayana. Suppose there are MBA students of 100 students are there. I can give them 100 sheets or one sheet or two sheets. They can write about Ramayana. They can write Ramayana, and each of them hold copyright in the way in which they wrote. See, each of them hold the copyright in the way in which they wrote. So all the 120 MBA students who have or faculty who have written this, they hold copyright in that. That is why it is always said that copyright is a very loose IPR. They call it. They lose IPR. See, whatever I have said now, I am interacting with all the students. Orally, whatever I say, there is no copyright over that. But once it's recorded, then it gets a copyright. Once it is recorded. And for instance, you will also find software programs. Software programs are written by software professionals. It is called as a coding. See, the software coding is covered under the copyright. But in industry where I work, they had a lot of CAD/CAM machines, computer-aided design, computer-aided manufacturing, like that machines. See, whatever we are doing manually some years back, some 2 or 3 decades back. The last 2 decades, CAD/CAM machines have come. So many of the operations have been standardized in that. So that machine moves according to the software coding written by the software engineer. So a second before I said that software coding is covered under copyright, but now I say that CAD/CAM machine moves because of the software coding that is inbuilt in the machine itself. So there is a difference in this. See, if the coding is part of the machine, then it gets a patent. But when it is not a part of the machine, it is covered under copyright. Now I'll give you another example. See, I'm pursuing CA course, so I used to go to banks for audit, CA audit. Bank audit, when you go, you will find when you go to a cashier, he gets money from you, and account number and all that you are giving in your slip, he is punching it like that. So it's a software. It's a software. That software is a central software. Imagine Infosys has made that software, that is Finacle. That software is called Finacle. Infosys has made a financial solution, that is banking solution for Canara Bank, Canara Bank. So this is put in the central server in Delhi, and all the offices, branches, and other head offices, or the software is shared by everybody. And London also. London Canara Bank is there, it can share. So global, nobody is this thing. So this is covered under copyright and not under patent. Why? Because the software can be removed from the hard disk. Where it is severable, it is copyright. Where it is part of the machine, embedded in the machine, the software gets protection under the under patent act. So there is a subtle difference between when you go to the software. So somebody has raised a point. I'll go to it. Chat in chat box. Hey, good morning. If I write one textbook and register under Copyright Act, after publication, that textbook in the market, if that textbook, if anyone can take photocopy in the Xerox shop, can I file a sue on the shop? Yes, you can sue. What is photocopy? You can take only a few papers of that. If you take the entire book, then he can be sued. You can sue him. Not only entire, substantial portion of the book. If somebody takes a Xerox copy and sells it for gain, then you can sue him. Yes, you can sue him, sir. You can, but books written by faculty, it is it comes under copyright. It comes under copyright. And performances. There is natak performances. Drama is also coming under Copyright Act. For instance, some nukkad, that is in the marketplace, some street plays were conducted, that is against drinking. See, nukkad is a marketplace where some social evils like drinking and all that, some 3-4 persons or 5 persons, they will enact a drama in the busy marketplace, so that gets the attraction from others, so it becomes an education for others. So this is also protected under Copyright Act. Poems are protected under Copyright Act. Prose is protected under Copyright Act. Music programs are protected under Copyright Act. A.R. Rahman music program. See, it also gets protection under the Copyright. Actually, music is Saptaswara. Sari, Gama, Pada, Nisa. The combination of Sari, Gama, Pada, Nisa produce different sounds. So a person who combines the Sari, Gama, Pada, Nisa in different meters and levels, he is called as a musician. He's a musician. So Sari, Gama, Pada, Nisa belongs to everybody. See, nobody can claim copyright over Sari, Gama, Pada, Nisa. But its permutations and the combinations the musician makes, it becomes melody. It becomes melody. So A.R. Rahman, like that, musicians, they can claim IPR rights under the Copyright Act. Who is the person who asked whether they may I know who has raised one point about and not only that, you will find that the intellectual property rights in the modern world, that is co-vaccine. And see, these medicines are produced to fight corona. Here also a question arises whether government can give any license to others to produce this medicine. So there is a provision in the Patent Act. It says that the government can give compulsory license to others in public interest to produce a particular medicine, but the royalty should be given to the original manufacturer or the original inventor, company or an institution. So government can take resort under the patent compulsory license regime. They can launch, and then Indian government can ask the biotech to give the chemical formula to others for producing the same, but biotech is entitled for some reasonable royalty for that. I think these companies have also agreed now. I'm saying yesterday newspapers, they have said we are ready to share the chemical formula with others. So because we need large, there are only 2 companies which are producing now. We require more medicines to cover 135 crores of people. So more companies should produce. So the issue of compulsory license under the patent regime will help produce more companies to produce it and serve the public interest. So that is one important, that is in the, and global level also, US, India has appealed to other countries to waive off patent rights, IPR rights, patent rights in respect of the COVID vaccine in global interest, global human interest they have. But we had some 12, 13 years ago, we had an interesting issue before the High Court. See, one multinational company, what it did, it produced a heart tablet, and the cost was around 8,000 rupees. And daily, minimum 2 tablets should be taken. And the box they consists of only 30 tablets. So it will come only for 15 days. Cost us 8,000 rupees. See, only rich people can afford for it. 15 days once 8,000. So monthly it is 16,000. Nobody can pay in India like that. So okay, then what happened? That multinational company which had produced that particular tablet, heart tablet, it was coming to an expiry. See, some 7 years expiry is there, date for pharmaceutical. In short, 20 years, 7 years. So 7 years when it comes nearby, what that multinational company had done was to give a chemical thing. A plus B is equal to C. A was that old tablet. B, they added one catalyst and they said it is C. It is C. It's a new tablet. So they wanted extension of the patent rights for another 7 years with this new medicine. They said C is a new medicine. Previous medicine was A is equal to C. Now it is A plus B is equal to capital C, and they say it's a new invention. New invention, 7 years. So it is called, this system is called evergreening of patents. You have made some patent and you want to evergreen it forever. Means make it live forever, whereas the patent regimes across the globe, they limit the pharmaceutical patents only for a limited number of years, that is 7 years like that. But the Director General of Patents, when the multinational company applied for patent, they refused. It said, we cannot give patent for this C. A plus B is equal to C, what you have said. Then the company said, C is a new tablet. Then Director General of Patent asked one question: what is this B? A plus B is equal to C. Previously, you are saying that A is equal to C. Now we have introduced B. What is this B? This B is a catalyst. It's a catalyst. So new one we have introduced. So it's a new tablet. Then the Director General Patent did not agree. Then the company, multinational company, went into High Court, Madras High Court. Incidentally, I'm from Chennai. Madras High Court. It was quite interesting to read that judgment itself. Madras High Court asked a question: what is this B again? Then the company said that it is a catalyst. Then it asked in science, what is catalyst? That which does not undergo any process, but it activates any process. Undergo any change, but it activates. Then Madras High Court said, so B is not a new formula, chemical formula. B is not a new chemical formula. Patent is given only for new chemical formula. Previously, you said A is equal to C. Now you introduce and say that B new one, and so this C, that is C1, what you have said is not, we cannot accept. Then when MNC, they appeal to Supreme Court. Supreme Court, the Supreme Court, they just ask a different type of question, because the catalyst issue was decided in this thing, in Madras High Court. Supreme Court asked, they just asked one more question: what is the therapeutic value? See, for instance, previously I was taking 2 tablets. Now I take only 1 tablet, the effect is same. So what it means, there is a therapeutic value. That is, there is an increase in dosage in one. That instead of taking 2 tablets, I am taking 1 tablet now. So it asked whether the new tablet has increased the therapeutic value. That is, previously the heart patient was taking 2 tablets. Now, how much he has to take? Multinational company is 2. So what is the use? It does not enhance the therapeutic value. And it also said the question of catalyst has already been decided by the Madras High Court. We are in full agreement with the Madras High Court. Chennai High Court, we are in a full agreement. So it refused. So this concept is called the evergreening of product. This every multinational company is doing it. Another a question of contention between India and other countries, developed countries, with regard to pharma products. There's one concept called generic medicine in patent, under patent. See, medicines are given under patents rights under the Patent Act. Medicines, tablets and all that. Tablets, injection, all. This generic medicine. What is this generic medicine? I'll give you an example. See, in foreign country, a heart tablet was invented, and in that country it is 7 years. 7 years is over, but now it has gone into the public domain. So anybody can manufacture that particular heart tablet without payment of any royalty or compensation to the inventor, that is the patent holder. Now, what India has done, India has more pharma companies. See, across the globe, India has more pharma companies, efficient pharma companies. India, that is why India is also called as the pharma of the world. Pharma of the world. It produces medicines and exports across many countries. Recently, when the COVID first wave was there, we exported medicines from India. For 55 countries we exported. Whereas in Europe and even in America, there are not much pharmaceutical companies. So these pharmaceutical companies, India, what it did, it took advantage of the ban. That is, after 7 years, when the medicine goes into public domain, or the technology goes into the public domain, or the chemical formula, molecule formula goes into public domain, it produces those medicines and exports to low-income countries like Africa and all that. even though it is 7 years old, but still people can eat and they can recover. Instead of 10 days, you can recover in 15 days, you can recover. Still, that medicine has got that potential. That chemical formula has got that potential. Molecular formula has got that potential. But African people and low-income countries cannot afford. So we are producing those medicines for which their patent expired in foreign countries, and we are manufacturing in India and exporting to other countries. So this is called, India is the pharma factory of the world. That is why it is called. This has got a certain opposition from developed countries like US, UK, USA, Germany, France. These these for developed countries, they threatened India, saying that you should not produce those generic medicines because you are producing the medicine without payment of any compensation to us, our inventors. See, there is a lot of investment is involved. R&D investment is involved in R&D department. For instance, whether it's an automobile or a medicine, a lot of R&D cost is involved. They are employing expert scientists in science to develop new medicine. Suppose they have spent something like 400 crores. The company will have to recover that 400 crores. What are R&D costs? Scientists' salary and the raw material for that. Everything costs. So that is why they almost many countries, they are against India for producing this generic medicine. But WTO has allowed us. See, you can generate generic medicines and export. Now, what are the various methods by which intellectual property rights can be enforced? See, somebody is violating my patent rights. I have invented a machine. Somebody is making the same machine without payment of royalty to me, and he is producing products. He is selling it outside, inside India, and he is exporting also. So, under such circumstances, how I can enforce my patent rights? So, India has got a judiciary is there. So, if anybody is violating patent rights, you can go to district courts, high courts, and on appeal you can go to Supreme Court also for the protection of patent rights. In fact, trademarks also. If somebody is violating the trademark of others, for instance, you will find on the road some cloths are sold, some shirts, cloths are sold on the road, and in that something like Reliance, like that, it is written. The customer is buying that. On seeing that Reliance, the Reliance that indicates the word, trademark word, Reliance indicates quality. So what you do, what the customer does, he buys the product without any question. But actually, it is not produced by Reliance. Actually, it is a local production of the cloth, and they are adding, superimposing Reliance symbol and word. They are doing it, and they are selling it. It's called as passing off. It's an offense. Passing off is an offense under the Indian trademark law. There is one Trademarks Act is in 1999. Under that, passing off is an offense, and you can always go to a civil court. The affected person, Reliance company, can go to, and denim. See, people are selling denim. There is a Reliance denim is there. Reliance denim. Some X or Y will produce the denim pant shirt and they will put Reliance like that. So the customer will buy that denim, assuming that it is a denim product from Reliance. So it is passing off a good as is good, whereas he has offended the provisions of Trademarks Act. So in that event, the Reliance company can move the district court for an order of injunction directing the offender not to sell goods not to sell it. And he can also get anten pillar injunction. That is, go and seize the product where it is stored, Yeah, I'll answer this. Yeah, I'll come to it. So he can go to that place where it is stored. It can be, the product can be seized also there. So in a trademark, it is the legally you can proceed against the offender. And patent, if somebody is offending the patent rights of another, the person whose interest is affected, that is the owner of the patent, or the inventor of that particular patent, he can proceed against the offender in civil court. They can go and file a case against him, get an injunction not to sell the product, recall the product. All you can get an injunction. Temporary. There are two types of injunctions are there. One is called temporary injunction. Another is called permanent injunction. Depending upon the severity of the case, the judge will give. Even sometimes he gives permanent injunction, restraining the offender, or in technical term, in law term, he can restrain the defendant from committing the offense under this act. So under patent, he can do it. As regards trade secret, one of our persons he has raised one question. We'll go to it. What is that? Chat. So what he has asked is stealing. No, somebody has asked is stealing. No, somebody had asked. Who has asked some question on trade secrets?
Sir, there is a question across.
Yeah, that's what I'm not able to see. That's I'm asking the chat.
Yes, sir. The question is stealing institution information or trade secrets a crime? And if I take
there are two things are there. Yeah. Trade secret. If the particular trade secret is obtained by some other person, he can use it. You can use it. It's not a crime. But the persons who are part of the trade secrets, suppose it's leaked by the persons who are in charge of the trade secrets, the company can proceed against them. So if you can get that trade secret, you can use it. You are not an offender. Why a trade secret is kept as a secret, others should not know. That is all. Others should not know about it. If I can get the trade secret without or in any different manner I can get it, I can use it, I am not the offender. But if the trade secret who are all in charge, suppose 4 people or 5 people, in the case of the Coca-Cola, they leak the information, then that Coca-Cola company can proceed against them. Why? Because they are all, the Coca-Cola is an employer, the company is an employer, and they are employee. There is a term in the appointment letter that employee shall not release or any confidential information that belongs to the employer. So a third party independently knowing the trade information, the trade secret, he can use it. The original person who has produced that trade secret cannot proceed against it, but they can proceed against their employees if they are leaking that information. So there is a master and servant relationship between them. So that is why trade secret is is strong as long as others do not know it. It is weak if other persons can come to know about it. That is called as a trade secret. Yeah. Any question in between? I want to. Then I will proceed further. Any person wants to ask any question? I will proceed further.
One more question along with this question itself. If I take Indian patents give protection worldwide.
Yeah, nowadays it's if there is a patent office is there in Nagpur. If you get a patent in India, you can enforce it against the whole world nowadays. You can enforce it against the whole world. Any other question? Hello? Any other question?
Sir, am I audible to you?
You are audible. You are very much audible, madam.
Yeah, thank you, sir. Sir, there is one more question from Professor Abraham.
Yeah.
The question is, if you trademark a brand or something in India, can you legally use that trademark to do business in another country, or must have to re-trademark there?
No. You can use it. Across the globe, you can use it. But the thing is, you should continually use it. I have explained to you what is continual and continuous. See, continuous is 2010, 2011, 2012, 2013, 2014. Continual is 2010, 2012, 2014. If you can prove that you have been continually using this, then you are protected. And there is no maximum number of years for protection for trademark. It is given for life. It is given for life, and every 10 years you have to register it. You have to re-register, pay amount to the government, the renewal amount. It is called as a renewal fee. You have to pay to the government. Yeah.
Okay. So thank you, sir. There are a few questions more. Would you like to answer now or at the end?
Right now. See, more applications. Okay. See, your questions are more application oriented. I work in companies. I also enjoy asking questions which have got applications. Yeah.
Okay. So the next question comes as, why does intellectual property need to be promoted and protected?
Yeah, one important question which you have asked, the very basis itself. For instance, you take Indian Vedas. Indian Vedas. See, Indian Vedas itself says knowledge should not be restricted. Knowledge should not be restricted. Knowledge should not be exploited for private benefits. We always say, Sarve Janaha Sukhino Bhavantu. Sarve Janaha Sukhino Bhavantu. So that all people live happily, and there is no monopoly concept under Vedas. That is why you will find Vedas, it is not written by one person. It is several rishis. Lord Narayana expounded it, and then several rishis have given their contribution to the Vedas. But the question, Western concept is, knowledge should be exploited for private benefit. Knowledge should be exploited for private benefit. What happens is, see, there is an incentive for a person. If you say your work, you will be given a royalty. You will be motivated more. Suppose you are given a royalty. Your work is recognized as yours, and you will get financial benefit. Naam, dam, mildata. If it is like that, people see, that is why Western concept of intellectual property rights is always towards compensating the inventor, so that there is more invention, more and more invention. See, more and more invention. So invention will not be there unless there is a financial benefit arising out of it. I don't think anybody will work without economic benefit. So it's an economic benefit that accrues to the inventor. So naturally, IPR rights are given to the inventor to promote further invention. See, otherwise, who will put money, time, and effort? See, this is a materialistic world now. During Vedas time, it was not materialistic world. So that is why Vedas said that there is no, you cannot exploit, don't exploit your knowledge for money. That India has already answered in Vedas. Next question, madam.
So the next question is, you had mentioned about how people should renew their copyrights after it gets expired. Does the time period of copyrights vary across the countries?
No, usually it is 60 years on the death of the author. See, for instance, A is an author who has written a book on business management. So, see, copyright exists for him until his death. See, up to his death plus 60 years. Plus 60 years. And suppose there are two authors are there. A and B have written a book on business management. Then A dies today, but B dies after 10 years from today. So the copyright protection extends from the death of B for another 60 years. That is B's death plus 60 years. Yeah.
Oh, thank you, sir.
Yeah. Any more questions?
Sir, the next question comes. Yes. So there are quite a few, many questions actually.
Yeah, you fire questions. You fire questions because there are more applications.
Okay.
Why I'm giving you, say, I work in industry.
Okay. So the
I
next
believe more in
question
applications. Yeah.
Okay. So the next question comes from Mr. Jesima. What are the international protection systems for GI?
Yeah, I already explained to you, Geographical Indications Act, every country has passed, every country. You go to America, you go to India, anywhere, Geographical Indications are passed, legislation is passed, and with that, the local talent, local knowledge, local talent, all these are protected at that. Local produce, all these, you take a Kashmiri Kambal, it has got a geographical GI tag. Kashmiri this thing. So every country has got its own law, and we get international geographical indication tag. We get what we have to do. What India does, for instance, from India. See, the moment a particular person says, "I'm producing this product, which is different from others, it can't be produced," then you have to apply to the government of India. There is a registrar of geographical indications tag office is there. Then that registrar will evaluate it across the globe. See, he will evaluate it across the globe. What is this particular? Suppose the basmati rice you take, it is not produced anywhere. There is no known practice of cultivating. So then the India will get a geographical indication tag. So no other country can claim that. See, for instance, I'll give you one more example. See, yoga is there. Yoga. YOGA. This yoga, American claim, American, one American said, Sarvanga yoga, Sarvangashta yoga, one is there. The entire body parts, they touch and everything is connected with the earth like that. So that enhances your happiness and your health. He said, I have invented, he said, that one American is I have invented. Then India objected. See, yoga, it originated only from India and not from any other places. So we objected in American court. He filed a case in American court. American court asked one question. The petitioner is the person who claimed. He said, you produce. Then he produced one machine. He said that if a person sits here and I operate, it touches every part of the body it touches. So in Sarvangashta yoga, like that he said. That said, you are not produced, you are not invented Sarvangashta yoga, you have invented a machine. You can get a patent for that. For that machine you can get, but not for the concept of yoga, you cannot get it. So this has already been, that belongs to a particular country, that particular territory. Champagne wine, I said, I gave an example. That wine cannot be manufactured qualitatively by any other country. So Champagne wine is a differentiated one in terms of the place from which it is coming or the process by which it is done. So that which is Tirupati Laddu, I have given you an example. Kannan, that's Assam tea, I have given an example. Darjeeling tea, because the soil condition, even within the country, varies from place to place, and it produces a taste of difference across the globe. Chikmagalur is known for coffee and tea estates in Karnataka. Now I'm in Bangalore, so I know about it. The tea tastes differently. So there is a GI tag is applicable, and you can get GI tag internationally. You can obtain it, and no other country can claim it.
Okay, so thank you. So the next question is,
Yeah.
Suppose I own a restaurant.
Yeah.
I have invented recipe for a particular dish and I am still inventing it. How can I protect while I am still inventing?
See, you are going to a restaurant. Basically, the inventing of this particular recipe is there is some taste is there, sweet, kara, like that. Some basics is there. Some basics are there. If it is made with that different mixtures and all that, it gives a different taste. But copyright is not given for that, or patent is not given. Yeah, patent is not given. But what happens? It will affect public interest. See, if somebody has invented a parota of a particular taste and he gets a patent for that, what will happen? Everybody will have to give royalty to him. In food items, generally the patent is not granted.
Okay.
Chemicals.
So there is one.
Yeah.
Please carry on. There are chemicals. You were saying something.
Yeah, some chemicals are there. You can get a patent for chemicals. See, combination of chemicals produces a different effect it gives. It brings in. So you can use it for medicine. So patent is granted for that.
Sir, there is another question across from Divya S. Siragam. The question is, what is the difference between a copyright and intellectual property?
There is see, intellectual property includes copyright also. Intellectual property, see, includes copyright. There is a difference between industrial property and copyright. Industrial properties, what are called as intellectual properties, or patents, designs. These are all industrial properties. With that which arises out of mind, that is, the copyright is different from that. So IPR, when you say, it includes copyright. All are called as intellectual property rights only. Yeah, next.
Okay. So next question is, can someone steal my ideas if I have a patent pending?
Yeah, this is a very, very good question. You are in the process of making a particular patent. If he steals, what happens? It's a crime under Indian Penal Code. In India, it is called as Indian Penal Code. In America, there is it's also a crime. In every country, it is a crime. Somebody steals some other person's idea, some other person's, not ideas. See, ideas you can take. There is no intellectual property rights on ideas and all that. But if you are putting that idea in your laboratory and you are in the process of inventing something, somebody comes into your laboratory and steals your note. The laboratory notes is very important one, where you write everything. Suppose steals that, it's a crime. It's a crime in every country. But the thing is, without, there are, see, human think alike across the globe. What you think? What's your good name, madam?
My name is Avinash, sir.
Avinash Kaur, madam. What you think, in the same way, across the globe, some 1,000 people will also think.
Right, sir.
So there is no protection on your idea or thinking. But only thing is that when it is implemented, you have implemented by through a patent. If somebody steals that, physically he steals that, or through your computer programs and all, through your email and so on, he steals that, is an offense.
Yeah. Okay. Right. Thank you, sir. So the next question is, protecting the created intellectuality is a challenge nowadays because of the cloning of one's idea is easier than the new creation. How can we tackle these circumstances in the business scenarios?
Cloning is done. Cloning of animals is generally not allowed. Cloning of animals. In fact, cloning of animals in public interest, it is allowed. See, for instance, some 15 years back, there was a cloning of one sheep, one separate breed they brought, but it died. After some 3 or 4 years, it died. So cloning by an individual is prohibited. But if that is done for some human benefit, it is allowed. Cloning.
Okay. So the next question is how intellectual property rights function or maybe works in e-learning industry and weapon industry.
Yeah, e-learning industry and
Weapon
industry. Weapons. See,
Yes, sir.
now you are touching a very sensitive area of IPR. For your information, for weapons, atomic bomb or weapons, see, there are two things are there. You take India and the rest of the world. In India, no private person can make any weapon. It is prohibited. Under Patent Act, if you develop a weapon, patent will not be granted in public interest. For instance, if somebody says that I am making an atomic bomb and you tell the government of India, I want patent for it, first you will be arrested. See, making atomic bomb is not allowed. You will not get patent also. It's an exemption under the Patent Act. But another, in foreign countries, see, you take the foreign countries. Suppose you take Italy, Bofors gun. See, we had Bofors gun. We have bought from Italy. There in foreign countries, it is legal to manufacture weapons. That countries, they allow it. US, UK, or Italy and all that, they allow it. So in that event, how the weapon is made, that particular individual has registered under Patent Act, then he will be protected. He will be granted patent. But every country has got the right to say that patent will not be granted for weapons. Yeah. And one more question you asked, what is that?
Yeah, so the other question was,
yeah.
So this is the one. The other question is a new question that we have come. This was only about the e-learning and the weapon industry, about intellectual properties.
E-learning, it is protected under Copyright Act. E-learning. For instance, now we are conducting one seminar on IPR. See, the property of who is the holder of this property is Oxford Institute of Management. So this particular thing, the same cannot be copied by any other person or one of the participants of you, assuming, cannot copy it and sell it. Seminar on I am giving you a seminar on IPR, you pay me 1,000 rupees like that, he cannot sell it. In the case of e-learning, the resource material and other directions that is contained in the e-learning material for the benefit of students is the IPR rights of that organization which has created that e-learning, and it is protected under Copyright Act.
Oh, fine. So thank you. So the next question is, if I sing a song of A.R. Rahman in a large mass of crowd or play his music, is that offensive? The question is put because once Ilayaraja had asked royalty from SPV for he sang one of his songs in Singapore.
Yeah, but he has to give credit to Ilayaraja. He cannot say that I have created this.
Okay.
He has to give credit to Ilayaraja. This song was from Ilayaraja. You can, for instance, there are some old classical songs are there from, it can be Telugu movie or Tamil movie and all that. They are sung by individual singers, even on the road. They collect money. They collect money. But the song belongs to somebody, but the singer is different. P. Susila has sang. Now I am singing that. Now I am singing. Using my talent, everything. It may be the same meter, everything it may be. But I have to give credit to P. Susila for that, or the poet who has written. I cannot say I have written this particular poem. I have written like that. You cannot say. So you have to give credit for them.
Okay.
Yeah,
So thank you.
I very much agree. There was some controversy between them at that time.
Yes.
But it was resolved peacefully because both of them were stalwarts. Both of them were stalwarts in their respective area. Both of them were stalwarts in their particular area, and they resolved the issue mutually. Yeah.
Okay. So the next question is, how do we get to know if someone else is using our trademark?
Yeah, you have to watch the market. Say you have to watch who is violating your rights. That is your job. That is not the government job to find out the thief and give it into your hands. Yeah.
Okay. So there is one more question. Many books are being published these days by rewording and resentencing with the same meaning. Is that an offense, or will he get a copyright for it?
See, the thing is, that is why I already told you, copyright is a very weak IPR. Weak, W-E-A-K, weak IPR. Why it is called as weak IPR? See, you can write Ramayana, the same Ramayana. I can also write Ramayana. The content is same, but the wording will be different. The wording will be different. So naturally, the person who has written in a different wording, he holds the copyright. So that is why it is said as unique IPR like that. You can restructure it because meaning is like an idea. Ideas are not protected under Copyright Act. Ideas are not protected. So naturally, you cannot proceed against the person if he rephrases, or you have to prove substantially he has copied it like that.
Okay, so thank you. So the next question is, can I get an intellectual property right just from the result of a research? This question has come across from Renuka.
Okay. You can see, suppose you have found out a new method or a process you have found out. You have to apply to the patent office. Patent office, you have to register it first. That is first protection. So who is giving the patent? Government of India, that is the Controller General is giving. So you have to apply. There are two procedures are there. One procedure is provisional specification. Suppose you are in the process of inventing and it has come to 60%, you can register your invention that I am doing this invention, it is continuing, and you can file a provisional specification. So that protects your interest. One. Another, when another 40% is also over, 100% is over, you have to file complete specification before the to the patent office. They will then put that your invention in patent journal. They will invite objections across the globe. Then if somebody is saying, contesting that I have already invented, then there will be an opposition proceedings before the Controller General. And if the Controller General feels that the objection of a foreigner, suppose the Indian is the patent claimant, his claim is not valid, then your claim will be accepted and you will be granted a patent. Usually, it takes 3 to 4 years in India to get a patent, whereas on an average, in USA you can get a patent within 1.5 to 2 years. So USA is leading in granting of patent. China is also the least period. Within least period they grant patent. But India, it takes even 4 to 5 years also to get a patent. So in this way, we have to improve our performance. Yeah.
So there is a question across to you. How does the intellectual property rights work in China? As we find most of the products we produce here, we find a clone. Does technology matter patent?
The thing is, in China, Chinese products are low cost and they produce in large quantities because of low cost, no doubt. But they produce the goods violating the patent rights of other inventors. But it is difficult to prove because where you can file your complaint, and it's very difficult across the globe. See, uh, that government will support. Chinese government will support that person. It's very difficult. We can file in suppose there is in Washington one inventor is there. His invention is copied by China, and they produce toys based on that. Toys based on that. Chinese toy is famous. Then you can file a case in China. You can file, and Chinese courts will decide whether he has violated or not. But largely, China is violating international IPRs. So there is one complaint is there, but very difficult. These are all very difficult to prove. Very difficult to prove. It takes long time. Cost is also involved. Cost is involved. Lot of cost. See, time, money, and once you put your energy into it, what will happen? You cannot work further. See, a scientist time is valuable, more valuable than money.
So thank you. So there is one question across.
Yeah.
Patent is granted to new investments only. Why?
New products that which already exist. No, new. It should be an advancement over the old technology. It should be an advancement. It should involve inventive step. It should be new, and also it should be capable of industrial application. See, merely inventing something, you cannot get a patent. Whether it is useful for industrial application, whether it involves inventive step, all these things will have to be satisfied. These conditions should be satisfied. Yeah.
Okay. So another question is, when a script writer goes to a director and tells the story, but he rejects the story, but later he films or directs the same story with the knowledge of the script writer, can the script writer file a case?
Yeah, he can file a case, provided he can prove that it was his idea which was conveyed to a director who has stolen his idea or the script. Yeah, like that cases have come up in courts. Courts have restrained also. Yes, but you have to prove the date of meeting, what you have conveyed. See, proof is needed. Concrete proof is needed.
Okay. Sir, I think...
See, for instance, I'll give one more instance. There are some writers are there. They write kahani. Kahani means stories they write. Suppose one story writer has written a story, one author, and it was written some 15 years back. One film director, what he does, he takes that story, whatever is there in the story, that book published, based on that he makes a film. So the story writer who has written the story, he can proceed against the producer of the film, saying that my idea, the characters, my idea has been reflected in the film. So he can. For instance, there is one Gramina song, very village song, that was copied in Vijay, Tamil actor Vijay's film. It was copied. So that Gramina person who sang in his village, that family sued. They said that you have copied that, the way and the words, everything. So you should give us compensation. And the film owner, Vijay and all that, actor Vijay is a big actor, so he didn't want any controversies and all that. He called them, he paid them a hefty compensation to that family, because the person who sang that song passed away already. Already had passed away. His family holds, they are the legal representative under law. They can claim. So when they went and met Vijay, then there was a meeting and they gave a lump sum amount for that family. So Gramina songs, village songs are employed in films, and suppose somebody has sang in village, he can claim it. So a lot of exploitation is happening in city from out of the village culture, village songs, village folk songs, village folk songs. They adapt in cinemas, but who is the owner of the folk song? If it cannot be firmly established, then you cannot proceed against the producer of the film. See, that way, many claims are failing. Yeah.
Sir, I guess these are the all questions for today for you.
No, you can ask 100 questions. You can ask 100 questions.
Sir, thank you so much actually for being so patient and answering, but these are only the questions we have across for you today. Sir, thank you so much for helping us to understand the basic concepts of copyright, patents, its significance of the intellectual property rights, and with such interesting examples, most importantly. Your examples
And, I would like to share that your college can also give a credit course of 2 credit course you can give on IPR for all the students for BCom, BBA. That will provide something, a knowledge which is different from others. See,
Yes, sir.
everybody adopt only university syllabus and all that, but this nobody is adopting. If you adopt this for a 2 credit course for BCom, particularly it is required for MBA course. See, MBA course is very much essential. Why? Because it is management of intellectual property rights. That is, patents, whatever that you get, you may not use it. You can sell it. You can give it for licensing. You can make money. So the MBA student should know with a 2 credit course about this IPR. Then it will be a value-added one, and you can say that you are providing a different degree than others. What other institutions they give. See, it can be an advertisement or it can be an add-on for your MBA course. It's very much absolutely essential. I'm very thankful for inviting me. And incidentally, I would like to share also our Honda where I work. We wanted that we did not have the trade name at that time. So our marketing department went to Honda management in Pune, and they said we need a trade name for our this thing. So we have to register our trade name like that. Then Japanese asked one thing: who is see by getting a trade name, in what way I am benefited? He said. Then we said that worldwide people will come to know about your product. Then he said, get out. Why? Honda is known everywhere by its quality. By its quality. He said, my quality is a message for the whole world. Merely because of a trade name, you could not claim it, he said. So that is an interesting insight that we got it from Honda management where I worked. I was in legal department. So yet we got it, we impressed them. That is only a few rupees that we spent for that. And 10 years protection we get it, and we continuously employ that in our products also. Then management Honda people agreed. But basically they said that these are all banawat part, all trade names and all that. See, what is the inherent? See, suppose you say there are on MA, MBA, LLB, MA, LLB, LLM, all these things with qualifications, all these, they are banawat but outer. So what is inside of Vijay, whether he is sincere? So Honda said the inside of Honda is a demonstration of quality in our products. Why our women buy our product? Because nowhere you can see a Honda product being stopped at a signal by a woman. See, they said that women buy our product because of the confidence in our product. So that is, see, always okay, IPR, trade names over, but basically the message is quality is the watchword for the consumer. Thank you, ma'am, for the opportunity.
Sir, actually, we should thank you, your sharing of experiences and your feedback and your idea of putting this into a course for our institution that will be surely taken into consideration. Sir, thank you so much. You have so well emphasized that the dire need has come that we shift our focus of investing. Instead of knowledge-based capital, we should rather focus on physical capital. So that was something which was very much needed for us to understand. Thank you so much for being with us and taking time out from your schedule to be with us on this workshop today.
Thank you, ma'am. Thank you. Thanks for all, Dr. Chitra Devi, ma'am, and Dr. Nikita madam, and Avinash Kaur madam. Very much thanks. And I will continue to contribute to Oxford Institute of Management forever.
Thank you. Thank you so much, sir, for being with us today.
Bye.
Bye. Moving forward, after such a substantial session today, we move on to the next speaker, a very prolific and generous personality. He is a senior partner at Banana IP Counsels, a premier IP firm based out of Bangalore, and leads the trademarks and copyrights, media and entertainment and IP licensing and transactional practices for the firm. Prior to Banana IP, he has worked for some of the leading Fortune 500 companies, such as Archer Daniels Midland and EMC Dell in an IP advisory, licensing, and transactions capacity in the United States. He holds a master's in intellectual property, commerce, and technology, and a Juris Doctorate degree from Franklin Pierce Law Center, United States of America. Our speaker has diverse experience advising clients on IP strategy, transactions, licensing, monetization, and dispute resolution in technology, entertainment, and digital industries. He also is the creator of the popular online IP and legal education initiative, Hegre Simplifies, which disperses simple to follow guidelines to the students and professionals through YouTube and other social media channels. It is my great honor and privilege to introduce to you a man of stature, compassion, and dedication in the field of intellectual property and legal education, Mr. Sanjeet Hegre. I welcome you, sir, to our workshop, and it will be really engaging for the audience to hear you speak on the business of intellectual property and opportunities for commerce and business students. I again request all the participants to disable their videos and audios. Kindly put across your questions again in the chat box, which will be answered at the end of the session. Mr. Sanjeet Hegre, I hand over the session to you. Sir, you are not audible. Hello. I'm so sorry, sir, but your voice is still not reaching out across to us.
Okay, how about now? Are you able to hear me?
Yes, sir, you're perfectly audible right now, sir. Thank you.
Having some audio issues, some internet issues, please excuse me. Thank you, Ms. Avinash. Thank you so much for the wonderful introduction. I'd like to thank the Oxford College of Business Management for this invitation to be able to speak to your various students and faculty members. I imagine are also part of this presentation. So thanks so much. A special thanks to Dr. Nikita, who I've known for a very long time. Thank you, Dr. Nikita, and I understand you as a principal, you're fairly new to Oxford, so thanks so much for starting this association between myself, my firm, Banana IP Counsels, and Oxford as well. So I had a chance to listen in on the previous presentation by Mr. Vijay Raghavan about various forms of intellectual property, and I think all of you had a lot of wonderful questions for him as related to the various forms and the application of those various forms. So my mission right now in my presentation to you is to give you a sense of intellectual property and business, the business of intellectual property, right? I mean, you're all business students, and that's probably what you're wondering. What do I do, or how do I interact with intellectual property in the various capacities I'm going to be involved with when I go into the working world or I start a business and such things? How does intellectual property interact with business, right? Or what is the business of intellectual property? So I'm going to share my screen. I have a PPT that has been done over here. Let me see if I can figure out how to share my screen. Okay. Are you all able to see this?
Yes, sir, your screen is visible to us.
Okay. So we'll talk about the business of intellectual property. I think for business students, the application of the various forms of intellectual assets that companies, organizations, individuals, what is created, how do you make money out of this, right? Or what are the opportunities you will have in terms of dealing with these kind of businesses, possibly in the form of employment, or possibly as entrepreneurs, maybe you will have startups that will deal with intellectual properties as you go along in your career. Okay. All right. So I think Mr. Vijay Raghavan has given you a sense of the various forms of intellectual property. I've listed the most significant intellectual property as related to business, right? There are many other forms, but the ones that we see, right, are these. Patents, which is legal protection that is given for inventions, right? I think this was covered in the previous session. Patents are given for inventions that are new, not done before, and such. The term of protection is for 20 years. After 20 years, your patent expires. So a good example will be a lot of pharmaceutical medications and such things, especially now given Corona. We've seen a lot of the co-vaccines and the COVID shields and such things that have come up. Well, these are usually protected in the form of patents. And these patents will exist for 20 years from when the invention happens, when you apply for it. So this will be good till now it's 2021. These were probably invented in 2020. So these you would imagine would be good till 2040 is when the patents would exist until. Once it expires, no renewal. Okay. Then you have another form of intellectual property called copyrights, which was covered with you. These covers the various works of authorship. This could be something that you've written in terms of written content. It could be a film you made. It could be a song that you've written and recorded. It could be a photograph, right? It could be a graphical interface, right? User interface on a mobile application or on your website. It covers all forms of creativity, right? And these creativities, when they're stored and they're replicable, meaning you can take a story and you can publish it and it's available and it's replicated on the World Wide Web. These are protected under copyrights. Copyrights usually have life of the author, meaning however long you live from when you create this work, plus 60 years, usually once you pass away, right? Those are copyrights. So the industry's patents, for example, let me go back. Where would you see a lot of patents? You would see a lot of patents in innovation-related companies. So innovation could be, say, Apple. Apple is a good example. Or Samsung. Samsung is a good example. They deal with a lot of patents, right? They are constantly innovating and they're protecting those innovations in the form of patents and they're leveraging it for their business. Copyrights. You see a lot of creativity or works of authorship coming from, say, the media and entertainment industry, right? So the Netflixes of the world, or the TV channels of the world, or film production companies of the world, they're all involved in the business of creativity, right? So for them, copyrights is a primary form of intellectual property that is important. Then your trademarks. Trademarks are representations used in trade or business, right? How long is the protection? It's perpetual. Perpetual in the sense that it's given for 10 years. And if you're using it, you have the opportunity of renewing it on 10-year intervals. So as long as you're using it, you can keep renewing. So where are trademarks important? Trademarks are brand names and logos, right? This is important for almost all organizations, right? Branding is a very important aspect of what they do. But there's also business related to trademarks, right? I'll get into this later, but examples could be franchising industry. Take the food industry, for example. McDonald's gives franchises for people who want to take those franchises and open a McDonald's. So what do you get? You get the ability to be able to use that trademark because that trademark is popular and it has a lot of brand recognition and goodwill. Goodwill meaning consumers, how we feel about that brand. That is what McDonald's is taking money from you to give you a franchise for, right? So that is the business of trademarks. Then you have industrial designs. These are also just known as designs. And these protect aesthetic designs, right? Things, the look and feel of products, manufactured products, industrially replicable products. So a good example of where industrial designs are used are industries like fashion, clothing. So a certain designer, for example, Sabyasachi, you might have heard of. Sabyasachi is a very well-known Indian designer, right? And does a lot of traditional Indian women's clothing. Most of those are protected by Sabyasachi under industrial designs, right? He files, or his organization, his company files for industrial design protection. And the term of that is 15 years, and it ends after that. It's not renewable, right? Also, the automotive industry, right? All the vehicles that you see, those are protected, the look and feel of that particular vehicle. Because when you see a Maruti, for example, a Maruti, I don't know, Alto. When you see an Alto, you know that Alto is different than a Hyundai i10, right? Because of the design of it, the shape of it. So Maruti wants to ensure that when we look at the Alto, it only is associated with Maruti, right? That we consumers only associate with Maruti. So that's protected under industrial designs. For term of protection, 15 years. Lastly, we have trade secrets. There is no registration for anything called trade secrets. Trade secrets are any confidential information of an organization, of a company, or an individual in terms of what they know that has economic value. Meaning, if that information gets out into a competitor's hand, that economic value depreciates or disappears, right? It's gone. So what could that be? For example, me as an organization, I have a customer list, right? These are all paying customers of mine. I have 200 of them, and they pay me X amount for the work that I do for them, right? Me, meaning my organization. Now, tomorrow, if that list, suppose it's a database or it's an Excel sheet, right, is stolen by my competitors, and they know who all my customers are, I have economic value to lose, right? Because why? They could approach those customers of mine. They know how much those customers are paying me, those clients are paying me, and they could try to steal those customers, which is going to be detrimental to me. I lose that opportunity, right? In terms of the economic value I have with it. So it's any form of confidential information. It could be things like client lists. It could be processes and systems that I have where I do certain things and I do it well. And I've learned those processes. I don't necessarily want to tell the world about it, or I don't want to tell my competitors about it, because I have economic value to gain by keeping that information confidential and not known to others. You as students, pretty soon, whenever you join the professional working world, the first thing you will likely sign with whatever organization you join will be an employment agreement. That employment agreement will have something called a confidentiality clause, non-disclosure clause. Non-disclosure agreement is a separate agreement, but those provisions are put into an employment agreement, which says that when you are working with us, you will be exposed to certain intellectual property or confidential information of the organization. You cannot take that information and divulge it readily. So tomorrow I start working for a company. I can't go on Facebook tomorrow and say, I'm working with such and such a company, and you won't believe all the information I have access to, or I do this and that, right? Or I support such clients and those clients are paying the company this much. This is all confidential information. So this is an obligation you will take when you sign that employment agreement, saying, I will protect the confidential information of my organization. Because that information walking out has detriment or loss of economic value to the company if it gets out, right? So those are employment agreements, and just preparing you for what you'll have to face in the coming years. Okay, so for the business students, there is a management guru, business management guru. His name is Peter Drucker, and he has given this very famous quote, right? And this is debated quite a bit. I'll just read it out. Because its purpose is to create a customer, business has two and only two functions: marketing and innovation. Marketing and innovation produce results. All the rest are costs. Okay, so I just want to read this out. Maybe students who are not studying marketing, or maybe students, business students who are here who are not part of innovation, right, or not engineering or science students, right, are feeling okay. But what about the rest of us? I'm a legal student and also a business student, right? We have people who are studying accounting and finance over here. We have people who might be specializing in HR over here. So basically what Peter Drucker is saying, all of us are cost to an organization. The only two functions that create results are marketing and innovation. Now, you would ask if I agree with this, and I do. I do agree with this to a great extent. So I'll walk you through this. So innovation primarily is protected under intellectual properties, right? These are intellectual assets an organization creates. Marketing is the selling, not just sales, but creating an impression in the market and creating the ability to be able to push that intellectual property into the market. That's the business. The rest are all costs to the company to support these two functions, innovation and marketing. Well, let me show you where business is going. Okay. I'd like you to take a look at this chart that I've put over here. This chart is the 50 most innovative companies last year, 2020, right? This is put out by BCG Global. BCG is the Boston Consulting Group, one of the most respected research and consulting organizations. And this is an annual list that they put out. I'd like you to see the top 10 companies over here, right? The most innovative companies in the world. Apple, Alphabet, which is a parent company of Google, right? Amazon, Microsoft, Samsung, Huawei, Alibaba, IBM, Sony, Facebook. These are all the most innovative companies in the world. I bet you if we looked at the largest companies in the world in terms of revenue, most of these top 10 would also make it onto that list, right? These are companies. So what I want to give you a sense is, innovation is the new business. Innovation is what is driving our modern day economy, right? So I made some points for you over here. What we know is intellectual property is not in isolation. All these various forms of intellectual property I mentioned to you, right? So a company would not just look at, okay, I want one patent. It's the business of intellectual property where all of these go hand in hand. They want to innovate, protect it in the form of patents. They want to push the marketing, which usually is in the form of trademarks or marketing by protecting your brand image and the goodwill associated with your innovation, the products or the service that you create, right? You have copyrights in terms of the creatives that you might be using as related to this, or you're a creatives company and you're pushing your creatives out in the form of copyrighted material that you're putting out for the world to consume, right? So you can see various forms of intellectual property is involved, and it doesn't work in isolation. A company just doesn't say, I have one patent, I'm happy, right? So that's what the first point means. It goes hand in hand. Intellectual property goes hand in hand with the various forms of intellectual property, and that aligns with the business's goal, right, in terms of what that business is trying to do. Most of these companies here are intellectual property companies. We are living in an IP economy. IP is modern day economy, right? You would see these are all the most recognizable companies that we know. And all of these are only in the business of creating and marketing intellectual properties. The other aspect of this is you have to innovate or you have to move out, right? You don't make it onto this list unless you're in the business of innovation, right? The current economy. So, example, here the last bullet point here I've said 18 years of longevity. Fortune 500 companies. So Fortune is basically a publication, right? I think I'm not sure, ma'am mentioned that I work for a couple of these companies. Basically, what it means, Fortune 500 are the largest companies, right, in terms of revenue. So starting with Fortune 1 all the way to Fortune 500, right? Fortune 1 being the largest, and they're on, right? They're on going down. Studies have shown that Fortune 500 companies, right, meaning that level of income, revenue these companies are making, right, where they're the largest in the world, right, going back about 50 years, those used to be able to stay on the Fortune 500 list for up to 50, 60 years, meaning a company which is making revenue will continue to make significant revenue for a duration of 50, 60 years, where they're successful in creating that kind of revenue. However, over the last 20, 25 years, we've noticed that Fortune 500 companies are frequently changing. They're entering the top 500 and they're exiting the top 500 as well. Why? Innovate or move out, right? The economy has changed. Our markets have changed. It's driven by innovation, various forms of intellectual property which protect it, right? And as long as you're innovating, you're able to stay in the highest revenue generating organizations in the world, Fortune 500, for example. But that duration, how long you're able to stay and sustain, is only 18 years now, right? It is no longer 50, 60 years like the older organizations from the like 50 years ago and onwards were able to do. Right? So that's what I mean. And you're seeing this. You're seeing examples of India. In India, you know, our economy has changed from the 1990s when I was entering the employment. I was studying and I was thinking about where to go. At that time, India's innovation, what we were known for is the world's back office. Right? We became very proficient at providing call centers to the world. Right? And that's what we started with. The level of innovation and efficiency that was, not efficiency, the level of innovation that was involved in back office function was not significantly high. But over time, as decade to decade, we've seen that economy evolve. We're no longer the call center to the world. A lot of Eastern European companies have taken over. Some Southeast Asian countries have taken over from us. Right? From a cost perspective, India doesn't make sense to a lot of industrialized and developed countries to send their call-related services to India anymore, right? Because our level of innovation and the type of work that we are able to produce and give to the world has changed, right? So what we've seen in the 2000s is more knowledge-based services is what we are providing to clients of ours, companies, which are based abroad. Okay, I'll get into this a little later, but you can also see that most of these top 10 innovative companies, right, they have a setup primarily in Bangalore, if not Bangalore, in Pune or Hyderabad, somewhere in India, right? Why? Because we are offering a lot of knowledge-based services now, which is on a higher level than the pure call center type of functions that we used to give previously. So our capabilities have significantly increased. So we are moving from just services-based to knowledge-based, and even within the knowledge domain, we are evolving where we are becoming higher and higher in terms of what we are able to offer. If you look at most of these companies, these are the most innovative companies in the world. You would see that these are not based in India. These are primarily American companies. You see some Korean companies here, like Samsung, and you also see Chinese companies like Huawei and Alibaba. Right? They are innovating locally, where we are not yet innovating to the level these companies are, where we are offering our innovation to the world. Primarily, we are seeing a lot of our innovation being done locally, addressing local requirements. So we haven't become an innovator for the world yet. However, a lot of these organizations are coming and setting up their innovation based in India, meaning they're hiring a lot. You know, India has one of the highest number of PhDs to offer, people with PhD qualifications to the world. So a lot of these people are getting opportunities to do research and development for most of these companies in India, right? So that is the service we're offering. But that innovation that we are coming out with, right, goes out and it benefits these companies which are based abroad. Our local companies, which I'll mention a little later, are yet innovating only for our local consumption, local requirements, right? So going back to my main point, innovate or move out. The type of organizations we see now are primarily driven by innovation. And innovation is basically intellectual property. And they use the various forms of intellectual property for the various business models they have. They protect it in the form of patents, they protect it in the form of copyrights, in the form of trade secrets, designs, and trademarks. Yeah, that is the idea. Okay, I'll keep moving quickly so I can get to questions. The Indian scenario quickly. Here, you can see on the left-hand side, the top applicants. These are patent applications in India in the year between the years 2018-19 and the previous year, 16-17. Okay, the lines that you see in blue are 18-19. I haven't gotten the most recent data, but this stays consistent. Most of the organizations here stay consistent. I want you to become used to seeing these, right? Because these are the companies which are investing in a lot of innovation in India, and the number of patents that they're filing and the number of patents that they're getting granted. Patents are protecting innovation, right? Inventions, right? These are usually the big players. Good number of these are multinationals which are from outside India, but they have R&D set up in India. these are possible employment opportunities for us. As we graduate, a lot of these companies will be hiring people. Okay, so Qualcomm is on the top. Qualcomm is an American company. It's into telecom. Huawei, again, Chinese company into telecom. Samsung, Korean company into telecom. Ericsson, I don't know where they're from. Ericsson, I don't know if it's from Sweden or France, but they're also into telecom. Philips, Japanese, they're also into electricals and telecom. Mitsubishi, they're into heavy machinery, also automotive. Japanese company. Oppo Mobile, right? Oppo, you know, it's from China, right? Telecom once again. Johnson & Johnson, J&J. So you get a sense here. These are the most innovative companies in our scenario, in the Indian scenario, right? So these are opportunities for us in terms of the intellectual property field. They deal with intellectual property. So we, as commerce students or business students, we don't necessarily have to be innovators. What I'm saying is we will deal with the innovation and the opportunities that these organizations create. These are the leaders in India. On the right-hand side, what I want you to get a sense of is where the opportunities are, where the economy is headed, where there'll be a lot of hiring, right? Where there will be opportunities for us to get jobs. These are the domains. These domains obviously are dealing with intellectual properties based on the filing activities. These domains are the ones where there's a lot of growth. Okay, so you can see electrical engineering domain, and that example, the Qualcomms and the Huawei's and the Samsungs and the Ericssons and the Philips, the top leading companies are into electrical and electronics. That's what this domain is. This is one of the fastest growing regions, sectors in India. And this is where we have a lot of opportunity. And what are these people into? They're into the business of intellectual property, creating IP and marketing IP. Okay. Then you have chemistry. We are seeing this a lot in the pharma industries that we have in India. Recently, with the coronavirus happening, you've seen the significance of places like the Serum Institute and Bharat Biotech and such organizations. Chemistry, including chemicals also, is a significant industry that is in growth in India in terms of the IP being created and therefore the opportunities for business through that IP. Mechanical engineering, you know, we are competing very hard with China to become the manufacturing option to the world, right? China is still leading. However, India has made significant strides in the last decade to, you know, in the last 10 to 15 years, where we have seen our industrial capabilities, mechanical engineering particularly, our manufacturing capabilities have become significantly better, and we are much more competitive now with the Chinese than we used to be. This is another domain we are seeing a lot of activity. Okay, then instruments. Instrumentation is a subcategory of mechanical. So where we are creating a small instrumentation and such things, these are small devices that are created that go into various products, right? Lastly, there's large category or other fields. But I wanted you to get a sense from this chart, where are IPs being created and what are the industries, and therefore which companies, right, are dealing with these IPs and marketing these IPs, and therefore what opportunities do we have for future employment, right? So electrical engineering and electronics, those kind of companies, followed by chemistry and pharmaceuticals, followed by mechanical engineering or industrial or manufacturing related sectors. These are the main sectors where we are seeing a lot of progress. And these are all IP related information that I'm providing you in terms of what these companies are doing. Okay. More quickly, I want to give a sense of trademarks also and branding, right? And the value that trademarks also create for organizations. On the left-hand side, quickly, this is the global ranking from Forbes that I'm providing you from last year of the most valuable brands in the world, right? I don't think any of us would be surprised at looking at all these brands, right? Apple is the most valuable brand. Google, Microsoft, Amazon, Facebook, Coca-Cola, Disney. The top 7 are all from the US. Then Samsung from Korea. Then Louis Vuitton. Louis Vuitton, I believe, is from France or from Switzerland. I'm not sure where they're based. Right? Then you have McDonald's, another American one. These are brands. This is the brand value that's been put over here. So, for example, Apple is valued at $241 billion. Okay, so $1 billion, I believe, right now might be about 7,400, 7,500 crores. 1 billion. is approximately 7,500 crores. So imagine Apple, just the brand, the trademark Apple, is worth 241 billion. This as an asset of Apple, the organization, this is the most valuable asset that they have. So you're surprised, right? Oh, I thought maybe it's the infrastructure they have, right? The buildings, right? I thought maybe they have a lot of innovation which is protected by patents. Yes, they do. But as a single asset, Apple as a brand, a trademark, is the most valuable asset that Apple has. So to give you some context, imagine tomorrow Google is able to buy the trademark Apple. Google has that kind of money, 241 billion. They pay Apple and they say, you give me the trademark Apple, right? So what does that get you? It gets you the right to be able to use the term Apple. So Google starts putting the term Apple on its products once they buy Apple. Apple as an organization can no longer use Apple. Will we as consumers pay the ridiculous amount of money that Apple charges us to buy their phone? I don't know. I don't have an Apple phone. I'm a Xiaomi phone user. I have a Poco phone, right? But an Apple phone costs, I think, something like 1.2, 1.3 lakhs for you to get. Why do we pay that? Yes, it is a good product. It has a lot of technology, but we are primarily paying that money because it has that half-bitten apple on the back, the logo. And everyone sees that I'm using an Apple, right? So that is the brand value we're talking about. And imagine if that brand, that ability of yours, that trademark of yours, is taken away from the organization. So you can no longer put Apple on the product. Will we buy it? Right? Will we buy it? Probably not. Right? If Google starts putting Apple on their phone, maybe I'll buy that. Right? Because it says Apple. So the trademark itself, independently, is the most valuable asset an organization has. Quickly on the right-hand side, these are Indian most valuable brands. Right? A lot of our financial services organizations have very good value in India in terms of brand recognition. The goodwill, meaning how we as consumers feel about that brand, right? The higher it is, the more valuable the brand is. So HDFC is the most valuable brand last year. They've recently come up that list. They were not the most valuable brand many years ago. And their value is it's about $20 billion, right? That's a significant amount, right? That's a significant amount. It's probably the most valuable single asset that HDFC has, followed by LIC, followed by TCS, followed by Airtel. Asian Paints. Asian Paints, amazingly, has been on the list for many, many, many decades. They continue to do really well. Though their market share really hasn't increased in terms of the paint business, the newer players, newer entrants who have taken a significant amount of market share. However, the brand valuation, the goodwill associated with the brand, how we feel about the brand has always been significant and has been very high. And therefore, you can see how many thousand crores in terms of dollars, it's almost $8 billion. Where is the value of Asian Paints, though they've existed for so long? Okay, so this is the branding business, right? This is the marketing business that we have to be aware of. Okay, I'll go through this. Then I'd like to open it up. I want to see what you've understood from what I've said about the IP business, right? Business of IP. So why is IP important for a company? Well, from my presentation, you've seen that there's various forms of intellectual property, and it has to go hand in hand, and it also has to go hand in hand with the organization's business plans. How they innovate, what they innovate, how they build brands, how they protect all of these in the various legal options available to them, and how they market it, right? So an IP provides business and competitive advantage to an organization, right? I have certain patents. For example, you might have seen that Apple and Samsung are always suing each other, right? They're suing each other, saying, in your new release of the phone, you have used certain patented technology of mine and you have not taken my authorization, or neither have I given you permission or license to use it, right? So I have business and competitive advantage where I'm able to stop competitors from using my intellectual property without my authorization, right? So it's a business competitive advantage. It's a marketing advantage to say that I have certain intellectual properties. I'm able to sell certain products better. Apple example I gave you. It's when you open an Apple phone, there's probably more than 100 patented technologies that are running that device, right? You also have the trademark, which again has significant value. That is a marketing advantage, right? We know the innovation that Apple stands for. We know the brand recognition that Apple provides and the goodwill associated with it. And we feel good when we buy an Apple product. So that's a marketing advantage. Intellectual property creates the opportunity for you to sell it, license it, or transfer it. Organizations are in the business of creating intellectual property. They put that intellectual property into their products or services. They sell it, or they license it, or they sell it off. They transfer all rights to it to somebody else. Right? So license, for example, software industry, take Microsoft. What you are running in terms of your laptop, right, or your computer runs on Microsoft, right? Or the Microsoft suite that we get, Microsoft Office, PowerPoint, which I'm running right now, all of these are licensed, right, to me. I pay a license fee to be able to use the intellectual property of Microsoft. That is their business. Okay. Certain other companies innovate and they sell it off. They don't license it. They don't want it. They don't rent it to you. They give it to you where you own it permanently. So these are the various business models that are out there. Ultimately, valuation for an organization. Why is IP important for a company? It provides valuation. Apple example you saw, $240-something billion, just a brand. Now imagine the other IPs that they have. They have patents, they have copyrights, right? These are all go hand in hand into the business model that Apple has, and they put it out into the market. What does that gain them? That gains them valuation. Okay. So why is important? Why is IP important? These are the reasons: business competitive advantage, marketing advantage. You have the ability to sell, license, or transfer it, and you also get increased valuation because you're in the IP business, right? You're in the business of creating IP and marketing that IP. Okay. I'll skip through this. I'll skip through this. I want to get to this. Then I want to open it up to you guys. So monetization, intellectual property, right? I was talking about sell, transfer, license, right? How do we make money? So I'll spend a little time on that, right? One, you create IP, you have various forms of intellectual property, you protected it, you filed, you innovate in India, you file for a patent in India, but you have markets in the US, you have markets in Europe, you have markets in East Asia. So you file for patents, copyright, trademarks, all of these over there, right? You're getting protection because you want to operate. You want to provide your product or service over there, you as an organization, right? So primarily, where companies in the business of intellectual property make money is in the business of licensing, right? Microsoft is a good example. Microsoft licenses all the software that they create. Okay, there's other organizations also, such as Qualcomm, which you saw having a high number of patents in India, the leader in patent activity in India. Qualcomm is a microchip company. Most of our devices, most of your handhelds or your phones right now will be running on either Intel or Qualcomm chips, microchips. That is only half of the business of Qualcomm. The other half of the business is innovation. They innovate, they file patents, and they give those licenses to those patents to practically every one of the phone companies in the world will be running on patents, right? Will have licensed the patents from people like Qualcomm. It's necessary, right? Or Ericsson, another well-known company. So they're in the business of innovation and licensing these to phone makers like Xiaomi, Poco, MI that I use. They don't do a lot of independent innovation, but they take licenses from all these other companies which are known for innovation. And every one of these phones that is sold, they get a percentage of that revenue goes back to the patent right holder. Okay. So licenses like Microsoft is in the business of software. Software is protected under copyrights. Software is treated and looked because software is code, right? It's zeros and ones. So zeros and ones are treated like a literary work, right? Literary work meaning a story that you might write. Okay, a story is protected under copyright. Similarly, copyright also applies to software. Primarily, the business is the business of licensing. This could be various forms, like I said. Then you also have sale of the intellectual property that you have created. This is not that frequent, but organizations do sell off some of the intellectual property at certain points, right? They might be acquired or they might be not using certain IPs that they have, which is not core to their business. so they'll be giving it to others. Organizations also cross-license, right? So they'll be trading. So I can give you examples of this. I used to, you saw that I used to work for an organization called EMC. EMC is Dell now, EMC Dell. And I used to manage relationships between EMC Dell and Oracle, IBM, right? And other companies. So we used to have basically cross-licensing is what we used to do. There will be certain innovation, certain IPs that I have as EMC Dell, and I want to license those across to Oracle or IBM in return for some of their IP. And we can develop products, we can develop services, and we can go to market with it together, right? So I used to handle those transactions of this IP transactions, right? The partnerships and such things. So those are cross-licensing. You give me mine, I give you yours. Let's put something together, we'll go to market with it, right? That's another way of putting intellectual property in the market. And there's other businesses which, in certain countries, you can use IP as a security and you can pledge it to the bank, right? It's an asset, definitely, and it can be used for you to get funding, loans, right? And such things. So we work with a lot of startups. My organization, also we advise a lot of startups, and we also advise a lot of private equity firms, right? So we usually get involved where a private equity firm is interested in investing in a startup, and we usually do an IP audit, right? So what is necessary to be done in that instance? So private equity firm will ask us, what is the value, what are all the intellectual properties that this startup has, and what is the value of that intellectual property, right? What is the competitive advantage this company would have as compared to their competitors, right? With the innovation they've come up, or with the branding that they've done, or with the copyrights that they have, or industrial designs that they have, right? What is the value? What is the competitive advantage? And therefore, is it worth for us to get into an investment round with this startup, right? So this is a evaluation that we do. So IP also becomes an asset which can be securitized, right? You can use it for funding. You can use it, pledge it to the bank because you need money, and the bank can hold it. So a good example would be Kingfisher. Kingfisher, when Vijay Mallya was having a lot of trouble and he was going under, he pledged Kingfisher, the brand, to the bank, because that brand is worth something, right? We all know what Kingfisher is, or at least last few years. I don't know, you guys are young. Going back more than 5 years, yeah, Kingfisher was probably one of the most recognized brands in India. So because of the financial issues he was having, he had pledged Kingfisher to the bank. And then when he didn't pay the assets back, Kingfisher liquidated on that trademark and it was sold, right? So this is a sense of monetization aspects of intellectual property, right? You're primarily licensing it, you're selling it, or you're cross-licensing, or you can use it as security as well, right? Hope I've given a good sense. Okay, now what I'd like to do is, I know Avinash ma'am said that everyone should mute, but if it's possible, Avinash ma'am, I want to run through this slide, but I'd like to get inputs from our students to see if they've understood what I've spoken about, and so I can clarify.
So sure, you can go ahead, you can have an interactive session with them, and you can please go ahead and ask the questions, or as you want to go ahead, you want to take questions directly from them, I would request the audience and the participants to please come forward and ask the questions.
Yes, thank you, thank you. So my first question is this. I've listed some companies here. I think with the exception of one, Domino's, all are Indian companies, right? You're familiar with these companies. Let's start with Flipkart. Can you tell me what are all the intellectual properties a company like Flipkart would be generating, would be using? Obviously, they have a very successful business that's running, right? So can I get inputs from someone who'd like to speak and let me know what forms of IP Flipkart generates and how does that benefit their business model? Don't make me speak more. Can I get some contribution, please?
I would please request the audience to please participate and answer the questions put across to you.
Hello, this is Rashmi here.
Yes, Rashmi, please take a try.
So obviously the trademark, copyrights, the design, the model that they follow.
Okay.
So for
What
all these
trademarks do they
things,
have?
yes, sir.
What trademarks do they have?
Regarding to the business itself,
Yes,
online
which
platform.
trademark is the question. Flipkart is the trademark, right?
Yes,
Do you think it's a valuable trademark?
yes, it is.
Yes. Why?
It has its own image.
Okay.
It has its own market positioning.
Right.
I mean, it has its own identity.
Absolutely. And today, when in India, if we're thinking online commerce, right, we want to buy something, there's probably only two places that we initially think about, right? It's either Flipkart or Amazon, correct?
Amazon, yeah,
Right.
correct.
Okay, so the significant value, like Apple example I was giving, Flipkart has created significant value for itself in India in the branding. Okay, then you mentioned copyrights. What do they have copyrights on?
It's somewhat similar to the trademark.
Copyrights, remember earlier I mentioned that copyrights can protect all creative works, including software, right? Software is also considered copyrightable.
Okay.
So primarily Flipkart, they're offering us an app or they're offering us software, right? We interact with software, isn't it? They've written a lot of code.
Right.
So that is usually protected under copyright. So they have a lot of copyrights for the code, for the function of this service that they offer us, which is e-commerce. Right? Okay. So you mentioned trademarks, you mentioned copyrights. Anything else? What about trade secrets? How would that trade secrets apply here? You remember what trade secrets are? Trade secrets are any confidential information of an organization, right, which has significant value for that organization. And if that information goes out into competitors' hands, the value of that trade secret is gone.
Have a bad market positioning because the information is let out.
Right. So what could be trade secrets of Flipkart that they will make all efforts to protect?
Maybe we could put it as their strategies.
Absolutely. Right. So say their processes for shipping out our products. So vendors who enroll on Flipkart, right, they have mechanisms where they can get it to us in the same day, or it might take 3 or 4 days, right? There's a certain process that they've set up. Over time, they refine that process. So tomorrow, if you want to start a competing company with Flipkart, you would want to know what that process is, right?
Correct.
Right, because you can get to market faster. You can
also we could design it better.
Yes, you can eliminate all the pain points. You don't have to go through the hard learnings. Flipkart has already done it and learned it. So let me also find out. Flipkart doesn't want to tell me that, right?
Right.
Good. Okay. Trademarks, copyrights, trade secrets you mentioned. Anything else?
Hello.
Yes.
Okay. This is Indu. So
Yes,
as you mentioned for the trade secrets, I would say like Flipkart has something called as FSNID. So that is the Flipkart serial number. So it is a unique product identifier for Flipkart, where this helps to get the order recognized by the Flipkart, and it will be confidential only for the Flipkart management and for the customer. It won't be like leaked out, or the secrets will be kept carefully.
Yeah. Very good. I don't know what that is, Indu, but thanks for telling us about it.
Yes, they use something called as FSNID. So that is where we can keep the customer's information confidentially.
Okay, it's probably software that's been written that does that, automates that. It's probably protectable as a patent as well, right? There could be patent possibilities in terms of what Flipkart has come up with. They could have protected under patent as well. Okay,
yes,
good. Thanks for the contribution. Let me get some more inputs. Let's go to Ola. Ola is no longer just in the business of providing you cabs, right? Booking cabs whenever you want it, wherever you go. But Ola also has gone into, in a big way, into electric mobility. right? Electric vehicles. They have acquired certain companies out of Europe, and Ola currently is setting up one of the largest electric vehicle manufacturing facilities in the world in India, right? So Ola is not just into booking cabs anymore, but they're also into electric mobility. They realize this is an area of opportunity for them to get into, right? Because we are moving away from fossil fuels, from diesel and petrol. We're moving into electric mobility, right? And this is the future. So Ola is getting into it in a big way. So can I get some contributions? Can all of you tell me, what do you think are all the intellectual properties that Ola has created or deals with that impacts their business, meaning the marketing that they do of this innovation? Can I get a sense? Anybody want to try? Okay. Avinash ma'am, I think your students are very quiet today. I think maybe what I've spoken about has not registered very well.
There's nothing as such. So they are not only students, we have other people as well. If somebody would like to just contribute towards your thinking towards the what sir has put across for the this companies, right now he's talking about Ola, you can please open up. And if you want, you can even put it across to the chat box. In the chat box, sorry, if you are not really very comfortable, I'll put it across to him. I'll read it out your answers.
No issues, no issues.
Yes, so I've given
I'll do
to them.
Yeah, Avinash ma'am, thank you. What I'll do, I'll just go through. I'll only brief everyone on these companies quickly in terms of their IP and IP models. Then maybe we can take questions. Maybe people would find it easier to type out the questions, and you can just read it out to me at the end of this.
Sure.
Yeah. So Ola, for example, again, is software driven, right? So you would have a lot of copyrights and you would have a lot of patents also. Patents are involved in terms of how they execute the function where you're able to locate cabs, right, in your vicinity, book a cab, and the cab, the driver is able to get the information, come find you, and such things, right? So software, protectable under copyright.
Along with licensing, no, sir?
Along with licensing, is that Rashmi? Yeah, what licensing, Rashmi?
Pardon me, sir?
Can you tell me exactly what you mean by licensing?
They need to have a license to actually, like, we use vehicles, for example, in Ola. So obviously we need to have a licensing. And also, like, under one umbrella you are working. So I think license is also an important thing for any company.
Okay,
and right now, yeah, Ola that we are speaking about, I think licensing is also like equally important as copyrights or trademarks.
Licensing, okay, I'll just clarify here. I understand where you're trying to come from. Licensing, when I say licensing, I'm talking about intellectual properties that you have and you're giving someone permission to use them, right? So Microsoft, example I gave you, they create software products, and then they give us consumers the license to be able to use it. Ola, on the other hand, creates their own software to be able to run the app, right, that we use, right? That software, they could have acquired it from somebody, some components of it. I'm sure they've taken licenses from other companies to be able to use it. And also Ola themselves have created a lot of that code, a lot of that software, right? And they're not giving us a license. They're not giving me the consumer license. They're giving me the consumer license to use the app.
Yeah, to a certain extent.
Right. So that is, yes, they're giving me a license to be able to use their app to book cabs. Right?
Okay.
That is correct. That is correct. Okay. So patents, copyrights, Ola branding is very significant, right? They're fighting with Uber. It's Uber, Ola, right? So branding is a significant part of what they do. There's a lot of brand value associated with Ola. Because it's so valuable as a brand, they get investments, right? They get significant investments from India and from abroad on an ongoing basis. And now they've taken very large investments to be able to expand into electric mobility, which because of that being a newer domain, right? There's a lot of innovation happening in electric mobility, and therefore patents are very significant for Ola and Ola Electric. Okay. Quickly, I'll go through the other ones, other models. Mahindra, I'll skip for now. Domino's. Okay. Which IPs, which forms of intellectual property do you think are significant for a company like Domino's? You would have gone to Domino's sometime. Anyone want to try this? What forms of intellectual property?
Sir, I think the secret spices that Domino's uses in his, I think, in pizzas or somewhere.
Yes.
The secret spices.
So trade secrets, right? Those are trade secrets. Like Mr. Vijay Raghavan was talking about Coke, I believe, right, earlier. The secret formula for making Coke. That's a trade secret, right?
Yes, sir.
So even the spices that we use, you're absolutely right. Even that, you know, the little spice packet and such things that they give us at Domino's, right? They have their own formula for how much to mix of what. They'll not easily tell us that, or how they make their dough, right? Or where they source their cheese from, right? Or where they get their sauce from. These are all trade secrets. What else is significant? What else is significant? One of the main forms of IP for a company like Domino's. I mentioned earlier when I was talking about trademarks. Why would trademarks be significant for an organization like Domino's? Trademark, Domino's is the trademark. What are they in the business of? How do they sell their food? Through franchises, right?
Yes.
Like someone takes a franchise, right? So what are you giving a license for? Domino's, the company, is giving a license to their trademark, to the franchisee, to be able to use the term Domino's to sell their products. Right, and that's significant, right? Because we all recognize what Domino's is. So I'm in Bangalore. Tomorrow I'll be traveling to Delhi. I don't know where to go eat, but if I see a Domino's sign, I know what I can expect in terms of food and the quality of food I'm going to get at that Domino's, because I recognize the brand. Right? So Domino's is in the business of trademarks. They're in the business of licensing others to be able to use that trademark and within it sell the products that Domino's gives them. Okay, good. So you see how I'm going through the list. Flipkart, a lot of software, a lot of copyrights is significant. Ola, I said electric mobility they're going to get into. Patents becomes important. Domino's, trademarks becomes important. Right? Not that Domino's will not have trade secrets or copyrights or patents, but the significant business is driven by trademarks, branding. Okay, lastly, for our production houses from India, Dharma Productions, you would know of this, right? Or any production. What are the forms of intellectual property they deal with? Which are the most significant for them, do you think? Where do they make their money from? Someone want to try?
Industry.
Yes.
Copyright.
Copyright, absolutely. Can you give me an example? Was it Mohammed who spoke?
Yes.
Mohammed, can you give me an example of the various assets a production house might have, right? Obviously, they're in the business of entertainment. What are the products that they're giving us? What does an entertainment company give us?
They'll have story.
Okay, take a film. Okay, Dharma Productions has done a film called Student of the Year and Student of the Year 2. I don't know if they're going to do Student of the Year 3 and all that. You guys might have seen it, right? In that one film, do you know how many assets, intellectual property assets are involved? Do you have an idea of what I'm talking about? Mohammed, any idea?
Just a little bit, sir. Like the title of the, like this title of the movie.
Yes, absolutely. That's a trademark.
This a story.
Story is one particular asset which is protected under copyrights as a literary work. Good. Anything else?
Songs, sir.
Absolutely. And within songs, there's many types of copyrights. Okay. I think you were asking about Ilayaraja and SPP issue earlier to Mr. Vijay Raghavan, right? So let me let you know, in a song, right, what the issue would be is a song itself. I'm sorry, I didn't hear that.
A message from movie to the public about the movie.
That's not necessarily an IP. Let me talk about songs. What I was saying about songs is there's various IP assets within that song. A song has three parts. The recording itself of the song is called a sound recording. That's one copyright. Within the song, you have lyrics. Those are the words that might be sung in that song, right? That is another form of another copyright. The third copyright is the composition. the tunes, the musical notes, those are also protected as another copyright. So just within that song, the producer of a film, right, will own 3 copyrights: lyrics, composition or the musical notes, and the sound recording itself. And a couple of those songs are put into a movie. The movie itself is called a cinematographic work, right? That's one copyright. But within that movie, like Mohammed said, you also have a story, which is a literary work. You have something called screenplay. You have dialogues. These are all different forms of literary works, right? Then you might have a performance. All our Indian movies will have one song and dance for sure, right? So that dance is choreographed. So that choreography is a form, right, of copyright. So you see the many assets that go into a product like a film. And all of these assets, Dharma Productions, or film production company, will be in the business of licensing. So once they make the film, they'll give licenses to theaters to display that film. They'll give license to TV channel to display that film. They'll give that license to OTTs or digital platforms like Netflix and Amazon Prime, the license to display it. They'll give licenses to TV shows, stage shows. Singing reality shows are very big right now, right? So they have to take a license from the music right holder. There's 3 licenses that they have to take, not just one. They have to take a license if they want to play a song on a musical reality show. They'll take a license for the lyrics, the composition, as well as the sound recording, right? So you see how many assets someone like a Dharma Production has. It isn't just one film. There's so many sub-elements to it. And Dharma is in the production, Dharma Production is in the business of creating these assets and licensing these assets. That is their revenue model. Okay, all right, with that I will end it. So I hope I've given you all a sense of the business of intellectual property, right? So we don't look at intellectual property just as one copyright, patent, trademark or something. What do companies do with it? And modern day economy is about creating IPs and marketing IPs, right? And I've given you examples of such companies over here in terms of the IPs that they create and how they put it to market, right? Now, we as business students, as commerce students, we have to find our opportunities in terms of prospective employments. I told you the sectors which are on the rise in India. Those are where modern day jobs are going to be. That might be as an accountant, that might be as a marketing person, right? That might be in the sales department, right? That might be in general operations, that might be in HR, right? So we have several different domains and the IPs that are involved. I hope I've made some clarifications for all of you as to how this works. So I'll end it with that. Avinash ma'am, if you'd like me to take any questions, I'd be happy to take a couple of questions.
Yes, sir. So there are a few questions across for you. So the first question is, what is meant by first copy or second copy of a branded consumer product, and how an original company will tackle these things under intellectual property rights?
Okay. So original copy and second copy. Second copy basically means it's a fake copy, right? So particularly if we're talking about electronic products or talking about garments, shoes, clothing, and such things, we saw a lot of counterfeit. Right? So counterfeit means it's a second copy. It has not been licensed by the IP owner, right? So for example, I'll tell you, you can walk down the street here in Bangalore and you will see a fake copy of a Ray-Ban sunglass, right? Ray-Ban sunglass, if you buy the original, I believe it must be something like 5,000, 6,000 rupees, but we can get a second copy for 100 rupees, right? It's a fake copy, which has not been authorized by the actual Ray-Ban. Ray-Ban, the company, has not given a license to that guy to make a 100 rupee copy and sell it. So how do we check this? How do we counter check this? Well, what happens is Ray-Ban has to keep an eye on the market. And when Ray-Ban sees that these products, fake products, second copy products are being put into the market, they have to get they have to identify who the manufacturer of that second copy is. 2, they have to file a case, and the police would be involved in that instance in terms of even setting up a raid to be able to raid the fake copies, the manufacturer of the fake copies, seize it and destroy it. That is usually the process. You don't have an automated process to check if a product is fake or real, But you would know, looking at the quality, we as consumers, we would know if something is fake in that manner. But then the responsibility really falls on the brand owner, Ray-Ban, to keep an eye on the market to see what is coming out that's fake.
Thank you, sir. So the next question is, what is the role of artificial intelligence in the field of intellectual property?
Artificial intelligence doesn't necessarily have a role in intellectual property. Artificial intelligence is a new expanding domain where a lot of IP is being created, right? Meaning AI is going into a lot of things we do, right? AI supposedly is simplifying our life through the form of, usually in the form of software. So that innovation that is coming through AI, artificial intelligence, is protected in the form of intellectual property, usually in the form of patents. Okay, so that is the role that IP plays in AI versus the other way around. AI playing the role in IP. You understood, right? AI is protected in the form of various types of intellectual property, primarily patents.
Okay, so thank you. So the next question is, does intellectual property work with politics? Interesting question, I suppose.
I don't know what is meant by that question.
Peter, if you would like to add something to make it clear, then you can put it across. I'll read it out for you. So we'll go to the next question by then. Okay. What else copyright protects except author's work and creation?
So copyright protects literary works, anything that we write, anything that we paint. So artistic, say painting, right? Photographs and cinematographic works, meaning audio-visual recordings that we've done. It protects sound recordings, things that we can hear, right, that we have recorded. These are the various forms. So even things like sculptures are protectable, right? An artist makes a sculpture, that is protectable. So these are the different areas which are protectable. It's the copyright's purpose is to protect creativity. And like I mentioned, software does fall under the copyright domain. That's one of the large areas.
Okay. So how long does a patent last?
You get a patent for 20 years and it's not renewable. So once that 20 years expires, like a trademark, you can renew it every 10 years, I mentioned, right? Whereas you can't do that with patent. Patent, you get 20 years. You as a company come up with an innovation, with an invention, and you get a patent on it. So you have the ability for 20 years to be able to put it into the market yourself and keep competitors from making that, right? So, for example, a drug, you're a pharmaceutical company, you have a patent on a drug. So only you are able to put that drug out into the market for 20 years, meaning you are able to make money from it for 20 years without competitors entering the same market. Okay, 20 years is the cap.
Okay, so we have the question by Peter about the intellectual property work with politics. He meant that like few ministers come up with some schemes and things for people, but after the other party comes into power, they don't follow up the same scheme. So he asks the question in this context. So do you think that intellectual property work with politics if we take this example?
Avinash ma'am, to be honest, I'm still not clear on what the question is asking. I don't see the connection between intellectual property and politics and schemes, right?
So, I would just ask the respondent in case. Peter, if you want to have a direct introduction, you can unmute yourself and then you can have a word with sir. Is it there?
Good afternoon, sir. It's Peter here.
Yeah, hi, Peter.
Sir, my question was like few ministers come up with schemes like when they come to power. After certain term period, they won't be in power. The other parties will come. But the scheme, what they introduce a startup, is that scheme having some time limit, or is that in that scheme they want some copyright or patent for that scheme? do they own a copyright of that scheme when they introduce ministers?
A scheme will not have a copyright, right, Peter?
Okay,
Or
sir.
a trademark.
It will have a time period. A scheme when they introduce it will be like a time period in the sense they will just introduce the team. After their power goes, even the scheme will go off, or the
Yeah,
scheme
but that
will.
has nothing to do with intellectual property, right, Peter? What does that have to do with intellectual property? Can you tell me the connection between a scheme and patents, copyrights, trademarks, trade secrets?
Because
And
mostly now, ministers and all, when they introduce a scheme, they introduce in their name. So in that way, I asked.
they introduce it in their name. Yeah, that doesn't mean they get a trademark for it, Peter. Okay, I think I get a sense of what you're talking about. They'll do a lot of marketing around a particular scheme, right? Right now, a lot of politicians are running around saying, I'm making oxygen canisters and I'm getting beds under a particular scheme, right? For people who need it. Such things. That doesn't necessarily mean it's intellectual property, right? The scheme, they might get a trademark for, right? Whatever the title of that scheme is, right? And that's what it is. That's owned as an asset, as a trademark. Like you would start a company and call your company ABC Company. That's a branding trademark. Tomorrow, if it doesn't, you're no longer the. I think I'm going off on a tangent here. Let me come back. I don't think there's a connection between schemes and intellectual property, right? The only connection I see is if a scheme has a name, that's protected under trademarks. That's it.
Okay. Thank you, sir. Thank you, sir.
Yeah, sure.
Yeah, okay. Thank you, Peter, and thank you, sir. So the next question is, why trademarks do not have expiry dates unlike patent and copyright?
Why trademarks have no expiry date like
Patents and copyright.
Okay. See, actually, I'm not sure why, right? I'm really not sure why, but I don't think there should be also. See, a brand name that you are creating is a recognition of your product or service, right? Or your company, right? It's a trade name that you're using. So as long as you're operating, right, you want that trade name and the value of that trade name because of the popularity you get to grow, right? So there is value in terms of it continuing perpetually. For example, Coca-Cola, I think, has been around since late 1800s, right? That's a brand. There's a lot of goodwill that's associated with that brand. So there's no expression. But if you ask what the logic is, I'm not really sure how to explain, give an answer to that. I don't know. I don't know the answer for that. I'll have to go into the historical philosophy of intellectual properties and look this up and come back to you sometime in the future. I don't have a proper answer for that.
Okay, so the next question, we'll move to the next question. Does intellectual property infringement always give rise to criminal liability?
Repeat that, please. I didn't get the question.
Yes, I'll repeat it for you, sir. Does intellectual property infringement always give rise to criminal liability? Okay,
not always. It doesn't always give rise to criminal liability. It's primarily a civil liability. But all of these, I think Mr. Vijay Raghavan might have spoken about the various forms of intellectual property, and they're under different acts, laws. So patent is under the Patent Act in India. Copyright is under the Copyright Act, trademark under the Trademark Act, and such, right? All of those acts, the laws, do have provisions for severe level infringement, right? Depending on the severity of the infringement, there are some criminal options available. But generally, most of the options that we have in terms of pursuing infringement, meaning misuse of our intellectual property, is a civil remedy, right? Is a civil remedy. Only rare circumstances might you have criminal liabilities involved.
Okay, so now we'll move to the next question.
Sure.
What is done to monitor IP infringement? What is done to monitor the intellectual properties infringement? Yeah.
So this is a very broad question. As you know, the various forms of intellectual property we've talked about, and they're very different, right? They protect different things. So a patent protects an invention, right? So our innovation, suppose we have a patent and the same innovation is put into market by somebody else. Usually how you know about it is, you know what your invention is and you know how that works, and you see another product out in the market and works similarly, then you know, okay, there's a possibility for an infringement. So how do you monitor it? Like the Ray-Ban example I gave you, a trademark there. How does Ray-Ban know? Ray-Ban has to keep an eye on the market, right? Ray-Ban has to see who else is putting out fake Ray-Ban products without their authorization. So monitoring, really there's no solution that is, say, like a software that I buy that monitors all my intellectual property. There is no such thing, right? You know what form of IP you have, and you know if you see it outside, right? Say a copyrighted work, we know. Suppose I made a song, and I have not. I'm sorry, I uploaded it on YouTube. Tomorrow I see copies of it floating around on YouTube. Others have uploaded it or they posted it in other platforms, right? I will find out, or someone will tell me, hey, your song is floating around. And I know I've not given permission to do that, right? So there's no automated way. It depends on the form of intellectual property. And usually the owner has to keep an eye on it. And when they find out someone is up to something that is considered infringement, then you have to pursue it in that manner. Then we will take up the legal options that are available to stop that.
So thank you. So the next question is, what are the dimensions of artificial intelligence in terms of IPR, and is it effective towards educational institutions? Should I repeat?
No, I think person who's asked this question, we need clarification, just like the political scheme question. This is a vague question. I don't know what is meant by this question.
Okay, so then let's move on to the next question. Does the company have a methodology for valuation of IP as a part of financing and mergers and acquisitions transactions?
Yes, absolutely. I imagine a finance person has asked this question. You're absolutely right. Intellectual property valuation is a form of valuation that has existed. It is not an exact science, but it is a very in-demand area within the finance domain where valuation of intellectual assets, right, intellectual property, people with that expertise, there's a lot of demand for it, right? Why? Because of the level of mergers and acquisitions that are happening, not just in India, but globally, but also the startups that have come up and the level of fundings that startups are looking for. There is a dire need for valuation of the intellectual assets of these organizations. So it usually happens during an investment round, or it happens during a merger round, right? Valuation of intellectual assets is necessary. So for all the finance students who are learning valuation, this could be an area that you want to specialize in. There's big demand for intellectual property valuation.
So there is one of the questions from another finance student. He says that I am a finance specialization student. How will this session of intellectual property rights help me? So he wants to have a little more detailed idea about it for finance background.
So as I mentioned, the valuation aspect of it, right? There's one significant aspect of it. So you're dealing with finance. If you're a finance student in the future, you'll be dealing with finance as related to IP, right? So you'll be in companies, you'll be in organizations which are in the business of creating and marketing intellectual properties, right? So when you're looking at it, it's not like valuing a physical asset, right? A building, right? The infrastructure that we have. It is looking at intangible assets, things that we can't put our hands on. So I showed you a slide earlier where the top ranked brands in the world and top ranked brands in India, right? Apple is valued at 241 billion. That's a valuation exercise that has been done, right? And that brand value helps in terms of bringing investments into Apple if they need it. Or suppose Apple is being acquired by someone, that brand value is something that an acquirer has to pay. So for finance students, this IP session and the goal behind this IP session is to realize most of the organizations you will go to work for are dealing with the creation of intellectual properties. So to be able to deal with the financial aspects, including valuation, is what I hope you will start getting an exposure to as you move ahead, knowing that IP is modern day economy.
Okay, so thank you. So there is two more questions. Do we have to renew trademark?
Yes, trademarks are for 10 years, but they're said to be perpetual in the sense that every 10 years you can renew it. And when you renew it, it renews for another 10 years. So as long as you're using it, you can keep renewing it for 10 years.
Okay. So the next question is, a patent assignment, is it given completely or only for few years? And once given, can it be taken back?
Good question. Assignment means when you assign a patent or when you assign anything or when you assign intellectual property, it means that you're transferring ownership rights. Okay. A license, so it's like an apartment, right? Like a flat. You can rent a flat. That's a license you take from the owner to use that facility for however long. When you buy the flat, you're taking an assignment of that flat from the previous owner, right? So when you're talking about patent assignment, the duration you have the patent is 20 years. You can decide how long you want to give that. You can assign it off to someone with the clause in that assignment saying complete ownership is transferred to you for say 5 years. After 5 years, I want complete assignment back. So it's like I'll sell you the flat, you own it and you use it however you want for 5 years, but in 5 years, you sell it back to me. That is what we're talking about, assignment. Okay, so that can be done, and that is a business deal, right? You negotiate that deal and you put it into a assignment agreement, and that's how you go about it. Yeah.
Okay, so thank you. So last question as of now. Is there any range of fees to be paid for own patents, copyrights, and trademark? If it is so, then what is the minimum and maximum range of fees to be paid?
Okay, when you say fees to be paid, I imagine for you to register one of these assets, right? To register a patent, to register a copyright, or register a trademark, right?
Right, sir.
Not to come up with one of those, right? Not the fees to come up with innovation that is patentable, right? That would be very difficult to quantify. So if you want to register for an invention or patent, the cost would be in India, the cost would be anywhere between 1 to 2 lakhs, the legal costs and the legal processes. If you want to register a copyright for artistic works, in India, the cost would be approximately 5 to 10,000. If you want to register a trademark for your brand, so that's the words, right, that represent your brand, your product, or even a logo, right, a visual presentation, a logo. The cost is approximately 25 to 30,000 in India. One of the things you have to remember is each of these rights, a patent, a copyright, a trademark, when you register it, it's country specific. So when I apply for it in India, I get rights in India. That doesn't mean I have rights, the same rights in other countries. Wherever I want to put my products or services out, which are protected under patents, copyrights, trademarks, I would have to go file for those in those countries. There are treaties between international countries, there are treaties between countries where we agree to give a certain level of recognition to the IPs from other countries. But for you to enforce those rights in those countries, meaning someone is misusing a right, suppose I have a copyright in India and say copyright for a film, and I know someone is cut, copying, pasting my film readily, easily, without my authorization in the US. I do have copyrights for it in the US, even if I haven't registered. But the law there limits me from going and filing a copyright case against the infringer in that country. I would need a registration in the US to be able to file a case and get damages given to me by the court. So it is recognized, but the level of things that you can do in terms of infringement will be limited if you don't have registration in those countries.
So, thank you so much.
I have a question.
Okay, yeah, we have a question.
Okay, last question.
Yes,
so this is so like, are ideas called as intellectual property, or what can be patented and what cannot be patented?
Okay, good question, Indu. So ideas are not intellectual property, right? An idea is not an intellectual property. When you talk about patents, you're getting a patent for an innovation, right? An invention that you come up with, right? It's a invention that is useful to society, as Mr. Vijay Raghavan had mentioned earlier. Ideas So suppose, I think earlier in the earlier session, previous session, someone had asked a question about, say someone has an idea for a film, some screenplay, some script, and they take it to a producer, right? If they didn't go with a script, but they just went to the producer and say, I have an idea of a film like this, that's not protectable. That's not an intellectual property. It's protectable when it's put into a script or a story, right? And thereafter, if the producer makes a film that looks exactly like your script or exactly like your story, you have a right to claim copyright infringement. So intellectual property, ideas, right, directly are not protectable as intellectual property. It's the expression of those ideas. It's protected as copyright or an invention, which is workable, it's feasible, right? I just can't say, I'm going to make water out of the air, right? Or I have the ability of, say, making a gun or a cannon which can shoot something from Earth to the moon. It's just not feasible, right? It's just not feasible, right? And for you to be able to prove that invention is very difficult, right? So because of the lack of feasibility on that, you can't get a patent. I hope I clarified to some extent what you're talking about, right? So ideas you can have. We have hundreds of ideas, but it's the expression, how you put it into either an invention which is workable, or you put it into paper in the form of a story you have or a song you have, then it's protectable as intellectual property.
Okay, only which is written or which is feasible is called as an intellectual property, you meant to say.
There are different, it depends on the idea and the different types of ideas, right? Inventions are protectable as patents. So you have an idea for to improve a product or a process, right? Or a new product or a process, it's protected as patents. You have a creative idea and you put it into paper or you put it into song or you put it into dance, that's protected as copyright. You have an idea for a brand, you protect it as a trademark. Hope that clarifies.
Yes, sir. Thank you.
Okay.
Thank you, Indu, and thank you so much, sir. Your session was really, your session was completely focused on the need of education, and it really inspired the youth for this generation. And it was very important for them to understand and to learn about safeguarding their inventions and their creativity through the intellectual property rights, which you have so well highlighted throughout your session. Along with that, your experience in industry and academia both have helped the students to understand the basic concepts of IPR very easily. Thank you so much, sir.
Thank you so much, Amnash man. Thanks for having me. Thanks to Professor Nikita, Dr. Nikita. My pleasure to be part of this session. Wish everyone all the best. Be safe. Thank you.
Thank you, Professor. Thank you. Bye, sir. And with this, we come to the end of the workshop on intellectual property rights. I would like to extend my thanks to the principal, the Oxford College of Business Management, Dr. Nikita Alur, for taking the initiative of organizing the workshop on this topic. Thank you, ma'am, for being such an inspiration like you have always been. I would also like to thank my heartfelt thanks to both our speakers, Mr. L. Vijayaraghavan and Mr. Sanjeet Hegre, for gracing our workshop with their presence and intellectual talks from their respective fields. Thank you, Mr. L. Vijayaraghavan, sir, and Mr. Sanjeet Hegre. I would also like to mention my gratitude to Dr. Chitra Devi, Professor, the Oxford College of Business Management, for her zeal and commitment for handling the whole event so flawlessly. Thank you so much, ma'am. Special thanks also to Mr. Prakash for the technical support throughout the workshop during both the sessions. Thank you so much, sir. And any event is never successful without its audience, and the same stands for us. I extend my thanks to all the participants from industry, academia, and the students who have been with us throughout the sessions and have been so interactive. Your questions have kept the session and the speakers to be so interactive and on the toes to reply to all of you. Thank you so much. We hope to see you all in the next future events with such enthusiasms. The feedback link for both the sessions have been shared in the chat box. I request all the participants to fill it before leaving the meeting. With this, we come to the end of the workshop. I thank all of you and have a blessed day ahead. Stay safe, everyone. Thank you for joining with us today.
Can I wait or can I end the session, ma'am?
Sir, you can end the session and you can leave, sir. So thank you for